Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Pilta and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Monday. It's Monday, just another manic Monday. Sorry I'm late. I couldn't find one of my cables because I was traveling and I wasn't sure where I put it. So hopefully I'm set up properly and you can hear me. And StreamYard is going to work today and YouTube is not going to be glitchy. But, it's Monday. So what can we expect? What can we expect? Well, we can expect some new filings today. We can expect some new droppings. I'm waiting on the motion to dismiss. There are things around it that have dropped, that have surfaced that we can talk about. Motion to impound portions of this motion to dismiss, which we know, I can imagine, was filed on Friday because I know the defense does not miss a deadline. However, we know that it wasn't indexed on Friday. It was not docketed. It was not scanned into the computer. We're going to roll with it. Hopefully it's going to surface by the time we are in the middle or somewhat of this stream. So settle in, because it's probably going to be a long morning. There's a lot of stuff to talk about, a lot of stuff to go over. How's everyone doing? Did everybody have a nice weekend? Did everyone have a nice spring break? Or not spring break, it was February break last week for a lot of kids, a lot of schools. So there's that. Okay. Tomorrow's going to be a big day. Tomorrow the hearing starts at 11. It's going to be a continuation of the grave concern hearing that we heard last week, the hearing last Tuesday that was abruptly cut short because of the grave concerns of Judge Cannone. So that's going to be exciting and fun starting at 11. And then I don't even know if they're going to continue the motions that were not heard last Tuesday. For example, the motion for sanctions and also the motion to exclude James Crosby as a witness for the Commonwealth. That was a defense motion. That was the one that Robert Alessi was in town to argue and was told no. Judge just abruptly adjourned that hearing and said, no, we're not doing that today. I have grave concerns about some things I just heard from Mr. Brennan that caused me grave concern about not only the defense, but defense counsel. And so I'm abruptly going to adjourn this hearing. You're going to have to come back next week and explain yourselves. Should be fire. I don't know. I have a feeling. Well, actually, I know that Hank Brennan misstated a lot of things. And then after the break, when he came up to correct the record, but that's not what he said he came up to do. He said, let me just, talk about the timeline. I need to add some timeline or something, in which he buried the lead that those email communications and the invoice that he was talking about from ARCA were provided to him from the defense, not the feds. Was it intentional? Was it negligence? Was it just word salad? An error in words? No, I don't think so, because he gave a huge monologue before that, building up to the fact that, his mic drop moment was going to be that he got all this stuff from the feds and the defense didn't give him this stuff and didn't turn it over. And, Mr. Yannetti said in court on June 10th, and then he gave this whole chronology. But if you go back and you listen to the beginning part of his spiel, he said he made a TUI request to the feds and it was non-responsive. Do you know what that means? You know what non-responsive means? I don't have to, dumb it down for anybody. Non-responsive means they didn't have anything to give him. So in the next breath, when he comes back to, give some more of his thoughts, he doesn't say that he's correcting the record, but he then says, oh, this was given to us by the defense, not the feds. Right. Because you said that your TUI letter, which you said originally also in your original spiel, it's a long, dark road or something like that. I know when I make a TUI request, I've been here before and it's a long, dark road that we never get, responses to. So yeah, it's wild. It's crazy, but here we are in the land of the upside down, the Matrix, Norfolk County, Massachusetts, and what it is. Thank you to everyone who has sent me. Multiple people have sent me. Dr. Marie Russell was apparently on some show called City Medical LA in 2001. It's on Amazon Prime Video. If anybody wants to go watch it, you can watch it. I haven't had a chance to. Season 1, episode 1. Several of you have sent that to me. I find that very interesting. And when I have an opportunity to go and watch that, I will. So thank you all for that. Let's see. All right. I just want to check the docket. Here's something interesting that happened last week, very quietly. Very quietly. The motion, you remember the motion that we went over that was made by the defense, in which they said to the court we should not have to turn over our impeachment materials to the Commonwealth, because what had happened was in the last trial, when we turned over our impeachment evidence, such as Jennifer McCabe's location data that showed that she went to Michael Lank's house, Sergeant Lank, remember Lank, the friendly, who had inserted himself in Albert business for decades, going all the way back to that case that we went over pre-trial, the Lapalito brothers, not sure how to pronounce it. Michael Lank had a history of inserting himself into the Albert family business. And Michael Lank was, the friendly that they were waiting for on the morning of January 29th of 2022 to come over to 34 Fairview. And he was also the guy, wasn't he, who Jennifer McCabe decided she should call around 9 a.m. to come back and add something to her statement that, she overheard Karen Reed saying in front of other officers at the scene, the scene being 34 Fairview. Did I hit him? Could I have hit him? Maybe I hit him in front of other officers, but she wasn't sure if anybody had written it down in their statement. So she wanted to make sure that Michael Lank wrote it down. Yeah, that guy. Well, remember, they were given the impeachment evidence ahead of time, because that was the prior court order during the first trial that they had to turn over to the defense in their automatic disclosure, any impeachment evidence. And the defense turned over to the prosecution the fact that Jennifer McCabe was at Michael Lank's house. What day was it? It was the 29th or the 30th, perhaps, of January. And went to Michael Lank's house, but then she had a whole story about why she went there, that, she was with Kerry Roberts in her car and they were driving around, and Kerry Roberts' daughter, son, was friend with Michael Lank's kid. And so they went over there and Jennifer McCabe sat in the car for like 45 minutes and the wife came out and sat in the car with them and they were just chit-chatting and stuff. And she had a whole story for it, because maybe she was impeached. Maybe she was prepped with her impeachment evidence. Yeah, that motion that the defense made last week. And then the Commonwealth opposed it because, they don't like trial by ambush. Trial by ambush is not a thing. Let me tell you also, it's not a thing where I practice in New York that you have to turn over your impeachment evidence to the other side. It's just not done. Well, that motion was quietly denied by Judge Cannone. And apparently it was maybe a scribble on the motion. It says it was signed and denied on the 19th of February. So the judge is going to have to, the defense is going to have to turn over all of their impeachment evidence to the prosecution because, the Commonwealth deserves a fair trial. Are you ducking kidding me? Are you ducking kidding me? I don't know where they are, where we are, but you know where we are. We're here. We're in the Twilight Zone. We have emojis for that. So that motion was quietly denied. It just appears on the docket as a little asterisk next to the docket entry. So interesting, not shocking, but it appears. So it's docket number. I was prepping on this last night, so I have notes. Hang on. It is docket number 493, docket number 493, which was the defendant's motion to reconsider reciprocal discovery order. That is the title of the motion. And after that hearing that we had last Tuesday, or they had last Tuesday, you and I were all together for that. And they argued that on the record, the motion, it says asterisk, 4 asterisks in a row. After hearing and consideration of the arguments, the motion is denied. All in caps, Cannone, J, dated 2/19/95, and a copy was emailed to all parties. So it's trial by ambush, or is it like trial strategy? Who's entitled to a fair trial here? Is Karen Reed entitled to a fair trial with evidence that they may have that may impeach witnesses, or should they all be prepped on that ahead of time? I don't know where the duck we are, but Tracy Walker is here and she's already gifted 5 memberships. So thank you, Tracy, for your kind and generous contribution to this channel, as always. And to those of you who are gifted, welcome. Dr. Russell's the GOAT is here from Norway, says, in my opinion, drama theater and smoke and mirrors. Thank you. Cajun Jumbo has been having Melanie withdrawals. Well, that's a lot of pressure, but thank you so much for your 10. And for thanking me for all that I do. I appreciate you so much. It's only been, we were together on Saturday for almost 3 hours while I was in an undisclosed location. So thank you so much. I love that you guys miss me. Thank you. For being on top of the super sticker. Thank you. And shout out to Tom Kokonowski, who's on a long drive today. He's the defense attorney for Brian Camp. We became friends after the Brian Camp trial. So for those of you who know, hey, Tom, what's up? I was talking to him this morning about what is going on here about this turning over of impeachment evidence, because it's not the way we do things in New York, but he's on a drive. So he's listening. So everyone say hi to Tom Kokonowski. Bernie says, Brennan protesteth too much. Shooketh, we are not. Yes, and also a big shout out to Tom Kokonowski's cat, George Clooney. Those of you who know, he came on. We did a show together after Brian Camp's acquittal, which was pretty awesome. For those of you who don't know, that was in Hampshire County. Brian Camp was acquitted after he was tried in a Hampshire County court in Massachusetts for shooting and taking the life of a home intruder who was preparing to perhaps kill him and his girlfriend and their 2 young children. And he was facing 20 years in prison, but thanks to his amazing defense attorney, Tom Kokonowski, he was acquitted. We watched that acquittal together, and that was awesome because we saw Brian Camp and then Daniel Penny and then Penny McGee all be acquitted in a row. So we had a trifecta of acquittals. We're hoping Karen Reed's going to be the 4th acquittal that we can watch together. Good morning, Elizabeth Lupus Lady. Thank you for thanking me. I appreciate you. And we'll address these other uncivil laws here. After our last stream, he did, I think, 2 streams on the appeal. He has a lot of knowledge with regard to constitutional law, federal law, and appellate work. So he did, I think, 2 streams on Karen Reed's appeal. And he comes in this morning and says, First Circuit precedent is better than I first thought. Karen Reed just might have a chance in federal court after all. Maybe there is a cause for some hope. Maybe. You know what else is a federal crime? Jury tampering. Jury tampering is a federal crime. And I find it so interesting. Thanks, Kurt, for your super chat. That the talking points yesterday, was it yesterday or the day before? The talking points for the Karen Reed haters, including she who will not be named, who allegedly, not allegedly, who absolutely tried to discredit me on court TV about a year ago in January 2024, by saying that I was some sort of, everyone who thinks they're a doctor comes in here and says that those are dog bites to John O'Keefe's right arm and they don't have any, and clearly that was my position on court TV, having been a trial lawyer who has handled thousands of car accidents during the course of my career, including pedestrian accidents. And it's been my opinion since the get-go that the injuries to John O'Keefe's right arm were not caused by a car. So pedestrian versus car motor vehicle accident, that's just not how it works. A pedestrian will always have bumper marks, bruising to the hips, thighs, knees, lower body. And it's my opinion that the injuries on John O'Keefe's right arm did not come from an exploding taillight. Well, that person who tried to discredit me twice on court TV by trying to make me look like I had no idea what I was talking about, and also by trying to get her, disparaging me on Twitter and such other things like that, calling me a grifter, a hack, somebody who doesn't know what I'm talking about, and being in it for the money and the clicks and the likes, and still to this day says such things like that about me on Twitter. She said on Twitter, and we're going to, I find this to be so interesting, because then, she says there's a million reposts on this. I'm not even going to put it up here. I'm just going to read it to you. So let's just, let's go there for a second. This was the talking point. Okay. For her on, what day was this? 23rd. What's today? Today's the 24th. So this was yesterday. She tweeted this at 11:16 a.m. So many of you guys sent this to me. She says, below are 3 examples of the blogger and his followers' crusade to tamper with the jury. They don't have facts on their side, so their best hope is another jury nullification. Another jury nullification? She's not an attorney. That's obvious. She says she used to work for the FBI. I think she's got the receipts to prove that, so I have no reason to doubt that. However, she hashtags Karen Reed, Justice for John O'Keefe, and then tags the following people: Mafia Masshole, Grant Smith Ellis, Yellow Cottage Cheese, and 2 other besties of Jennifer McCabe in her tweet. So the talking points for, see, it's got 31 retweets and over 20,000 views. Jury tampering was the talking point for yesterday, which is so interesting, because it's just around the time that other creators and people have started talking about jury tampering, but not by people outside the court who happen to think that John O'Keefe was not hit by a car. No, jury tampering potentially by, I don't know, the Massachusetts state trooper who was assigned to oversee the jury in the Karen Reed case during the first trial. Because Alan Jackson was very vocal on the Ted Daniel interview that we watched, talking about that and about, we know it's Trooper Fanning. Trooper Fanning was also in charge of the Sandra Birchmore investigation, and in that case, they did not find that there were any, they did not think that Matthew Farwell was a suspect in the death of Sandra Birchmore. They ruled that a suicide, right? Trooper Fanning, who was in charge of all of the law enforcement officers involved in the investigation of the murder of John O'Keefe, and Trooper Fanning, who was also included in the group text messages of Michael Proctor. And then I think after the trial found himself in a little bit of hot water with internal affairs, but he was eventually cleared, I believe. So if any of the disgruntled jurors who were kicked off the jury, there's been some rumblings that perhaps there was a juror who was kicked off the jury right before deliberations. She was removed from the jury. The hypothesis for that is that Trooper Fanning told the judge somebody had overheard this juror in a bar talking about the case. I'm not really sure what the alleged grounds for that were, because, those sidebars were never made public. Was anybody following the jurors around? Who would have heard that? Was that completely unfounded? Do you remember the Murdoch case? Because I know you do, because we went over this together. When Becky Hill, the court clerk, went into the judge in the Murdoch case and said, the Egg Lady juror's ex-husband had been posting on Facebook that his wife was on the jury, and some crazy shenanigans that could never be proven because these Facebook posts didn't really exist. And then when they found them, these Facebook posts, it turned out to be not Egg Lady juror's ex-husband. It was wild. Thank you, Magnolia Gypsy. Why was Fanning in contact with the jury at all? Anybody, even if you think Karen Read is guilty and intentionally murdered John O'Keefe, do you not think that there is the appearance of impropriety in having a Massachusetts state trooper who was involved in this investigation, involved in the Birchmore investigation, anywhere near the jury in this case? Do you think that that is in some way okay? Because it's not. Magnolia Gypsy says it doesn't matter if Fanning said anything or not to the jury. It's mere proximity that could be tampering. Yes. And that is why state troopers and law enforcement are not in charge of juries, because it can be intimidating to the jurors. That is why court officers are assigned to that duty. Many people have pointed out that perhaps judicial immunity could be compromised in a situation such as that, because not only is Judge Cannone the judge in this case, the trial judge, but she's also the administrative judge for Norfolk County. And while I have not had the chance to dive more deeply into it, there is some reason to believe that perhaps administrative duties of a judge are not subject to judicial immunity. That is a possibility. If, and I don't know if, but if the judge assigned Trooper Fanning to oversee the jury in the Karen Read case, despite a clear conflict of interest there on behalf of Trooper Fanning, could that be considered jury tampering? Could it be? Could that be a federal crime? I don't know. Could that be something that shook her to the core the other day when she took her little time out and came back shaking like a leaf? I don't know. But Tom says, and Fanning and Norfolk County District Attorneys still don't think Farwell did anything wrong, as there are still no charges brought by them. Yes. Tracy V says, Fanning is the new Becky Hill. Yep. There was something else that I had bookmarked, so let me get to that for a second. But it seems like perhaps people on the other side of the fence were told to talk about jury tampering, but distract. Look over here. Look over here. Look the other way. Oh, look, something shiny. Let's talk about jury tampering, but let's blame Turtle Boy. Turtle Boy. Turtle Boy. It's all Turtle Boy tampering with the jury. Are you ducking kidding me? I don't know. That's my opinion. It's my opinion, because it seems like they were given some talking points, and those of you who know. Here's a quick clip of the portion that I'm talking about of the Boston 25 interview in which it's discussed. And are they running scared about this? I don't know. Should they be? I think so. My opinion, of course, as always, only. Listen. This is the portion of that Ted Daniel interview that we watched. I don't know when it was, a week ago or two.
One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury?
Right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was a direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination, the presentation of our case. That person, that supervisor, we found out well into the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors.
What?
That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest.
Is that standard in Massachusetts for just the DA's office to assign whoever they want to go be the sort of,
supervisor
of the jury? Yeah.
The is it standard in Massachusetts? I hope not. I've never seen that in my life. But if I had a nickel for every time I said I've never seen this in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels. I've never seen that happen. It should never have happened. It's abhorrent to the system of justice in which we work. those kinds of conflicts of interest, they just can't stand. But they did. And we weren't even told about it. I mean, that was one of the most galling parts of that revelation, is that, wait, this has been happening under our nose the entire trial?
Yeah.
And I'm just now finding out about it? We would have made hay about it as soon as we found out. And we did. But it was 10 minutes before I was about to stand up and close the case.
Wow. They didn't even find out about it until the end of the case, 10 minutes before his closing. Magnolia Gypsy says, because Bev watched Karen's interview. Then that federal appeal drops during the hearing. Bev is freaked. Kurt, if you're still listening, I'm curious about this. I'm curious if this could be brought up in a federal habeas type petition, separate and apart from the other one. I don't know. You're the guy. You're the guy on this. So if you need research, I have some research I can send to you. But I'm curious, how did they think this wouldn't come out? And listen, those jurors who were dismissed, it's been pointed out that there were 3 very pro-Karen Read jurors that were the one that was kicked out the morning of deliberations based on this alleged information from Fanning that she had been overheard in a bar talking about the case. And then the 2 female jurors who were picked as alternates at the very tail end of the case, who were also very pro-Karen Read. If they're disgruntled and there was any interactions with Fanning, or they can shed some light into the fact that Fanning was assigned to this jury, or perhaps the feds saw this interview and now they're like, what? They could call those jurors in and question them, separate and apart from the double jeopardy issue. So I think there's maybe going to be some more things that could come out about this. That's my opinion. That's what I would do. But you heard what Alan Jackson said. They didn't even have any idea that this was happening throughout the course of the trial. They found out at the very last minute. And that's insane. Excuse me? I don't believe that picking a lawyer from LA was a mistake. Why would that be a mistake? Says Slippin' Pete. I don't know who you are, Slippin' Pete, but I do not think it was a mistake to pick an LA an LA attorney to come in and try this case, who's wildly experienced and is an excellent, in my opinion, supplement and partner to David Yannetti in this case. I think they complement each other beautifully. So I don't think it was a mistake at all. I'm not sure why you would think that, but everyone's entitled to their opinion, as are you. Let's take a look at the most recent droppings, because we've got stuff to talk about. All right. Let us talk about docket number 515. This is docket number 515, which is defense's motion to exclude certain testimony of the Commonwealth witness, Robert Gilman. This is the weatherman. Did you guys tell me that he was a famous weatherman in Boston for many years? Is that the guy? Is that the guy? They've noticed him as a witness, and Robert Alessi isn't happy about it, so he drafted a motion, or he wants at least portions of his testimony excluded. We are hoping, as always, or as pointed out at the beginning of the stream, that the motion to dismiss is going to hopefully drop during the course of this stream. This one was filed this morning on the 24th, so that's interesting to me because the deadline on the defense motion to dismiss was Friday. And let me just check the docket again. I don't think that it's hit the docket. This is 515, 516, which I also have, and 517, which I also have, which we will go over. It's defendant's motion to impound portions of the defendant's motion to dismiss for extraordinary governmental misconduct, and the affidavit in support by Elizabeth Little. So we've got all 3 of those things, but perhaps they're waiting for the judge to rule on that before they post it to the docket. So let's take a look. Slippin' Pete is a troll. My mods are so on it. And trust me when I tell you that we investigate let's just say we know a lot. We know a lot about OSINT, and there are a lot of people that are being watched. Just, it's funny. It's funny. That people think that that we don't know who they are, but we do know who they are. Oh, that's a new one for me. Slippery Peter. Yeah. I don't know, whatever. Good morning. Here we go. Docket number 515 is docket number 515. Let me just fix the orientation of my phone. Give me a second. Nothing's cooperating today. It's another Monday. Just another Monday is all. That's all. That's all it is. Let's see if we can get this up. Everyone hit the like button while I'm thinking of it so I don't have to turn off the air conditioning or the heat or anything else such as like that. All right. The mods are the best on this channel. They are. And also the chat is the best. You guys are hilarious. You guys are amazing. I love you so much. It's like a really fun snark tank here. And you guys are in a competition for best username. You change your usernames to match the case, and it's just another manic Monday. We think in song lyrics here. And this is how we do it. This is the defense's motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative, request for Daubert Lanigan hearing. And this is filed by our friend, Robert Alessi, New York extraordinary attorney who is working pro bono, which means for free, for the defense. My red pen is here and I'm ready. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully moves this honorable court to exclude the testimony of Robert Gilman, Mr. Gilman, concerning the hardness of the ground in and around the lawn area of 34 Fairview Road in Canton, Massachusetts, in the evening of January 28th, 2022. It's hard to not laugh because this is funny. And the early morning of January 29th, 2022. Yes, they would like him to come in and testify about the hardness of the ground in and around the lawn area. And I guess it's going to be their a new theory of the case that because the ground was so hard and frozen, that could have fractured Officer O'Keefe's skull in many places and caused the subarachnoid hemorrhages and whatever other brain bleeds and assorted brain injuries that he sustained as a result of this not car accident, that it would be from, smacking his head on the ground because he's a weatherman. So he should be able to testify to that, right? Yeah, no, not how it works. But maybe he does in Massachusetts. Who the duck knows? Exclusion of the testimony is compelled because the Commonwealth has failed to meet its burden under the Daubert-Lanigan framework as to both Mr. Gilman's qualifications and methodology. There's that word. There's that word that Hank Brennan loves. Methodology. See Daubert and Lanigan. And isn't this weird because, just as a side note, wasn't Ms. Gilman the tech person for the Commonwealth in the first persecution of Karen Reed? Wasn't it Ms. Gilman? Like, Ms. Gilman, can you pull up this exhibit? Ms. Gilman, can you do this? And then that position was filled by Colleen Crawford in the Penny McGee trial. So that's interesting. I guess Colleen Crawford can't be the tech person for the Commonwealth in the re-persecution because she's a witness. Interesting. Back to the document. That is, Mr. Gilman is not qualified to render the opinion on the subject of the hardness of the ground that he proffers. Neither Mr. Gilman nor the Commonwealth has put forth any information regarding Mr. Gilman's qualifications to testify as an expert about the ground's hardness and the requisite geology, hydrogeology, and other like scientific precepts necessary to opine on the supposed hardness. I mean, you can't make this up. Can't make this up. And if you want to talk about hardness, go look at the photos of Yuri Buchanan arresting Karen Reed in June of 2022 outside her house. There's some screenshots of that. You can find them. Keep it clean in the chat, please. And that's that. That's all I'm going to say. Additionally, the Commonwealth has failed to satisfy the method, and that doesn't give we're not going to, distract the chat on that, but you can just put a pin in it for later. Yeah, it's a Monday. It's a spicy Monday. Spicy is not my favorite word, though. Let's think of another word for spicy, like a synonym for spicy. keeping this clean is a real challenge, I know. And that's why we're not going to talk about, anything from like Duncan or, that whole Paula Keefe thing, which, by the way, I'm going to show the video. Remind me later. Okay, here we go. I digress. Additionally, the Commonwealth has failed to satisfy the methodology prong of the Daubert Lanigan analysis because Mr. Gilman proffers no methodology of any kind in his report or in any of the other materials supplied by the Commonwealth. Mr. Gilman cannot show that his lacking methodology is generally accepted in the relevant scientific community, as there is no methodology to scrutinize. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony. Mr. Gilman fails both prongs. Argument. 1, the Commonwealth fails to meet its burden to establish the requisite qualifications of Mr. Gilman as an expert to testify about the hardness of the ground. And that is what they called it in their motion. It wasn't even a motion. I guess it was an exchange. It was a report. They exchanged a report. They said they intended to call him at trial, and that's what he was going to testify about, the hardness of the ground. It's crazy. I don't know. I don't know how this is true, but it's a growing channel. Bulani Casey says, how does Melanie have over 6,000 watching on a Monday morning and not over 100,000 subs? Hopefully she gets there. We're only a year and a half old, so we're doing great. But, hitting the subscribe button is free. It's free. Make sure you have all notifications set too, because I was bummed the other day when I realized that I subscribed to people and I was not getting all notifications. And I thought to myself, where's Natalie, the lawyer chick? I haven't seen her in a long time. I've been on her show. And I went over and she had posted a whole bunch of videos that were not coming up in my feed because when I went to my notifications, it was like personalized. And I guess they didn't personalize me to be getting the notifications from her that I wanted. So make sure you're set to all notifications. But we're trying to get to 100, so let's do it. You guys can help with that. And I love Natalie, the lawyer chick. That's a side note. Where are we here? Where are we? It is the defendant's burden to establish that their proffered expert's testimony, quote, will assist the trier of fact to understand the evidence or to determine a fact in issue, according to the Massachusetts Rule 702 in a couple of cases, which we know because we've been over a lot of these motions that are very similar and the same cases are often cited. And we know all the prongs of Daubert-Lanigan, not that we ever wanted to, but we know them. The crucial issue in Massachusetts for a Daubert-Lanigan inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject matter of his testimony. Citing Rintala, which we've also been over, that case involved a paint drying expert who did experiments in his basement about how long it took a certain paint to dry, and the court excluded the testimony. And it was like, yeah, no, you can't do that. Fiery. Maybe fiery is good. It's like Fiery Monday. Thanks, Katie. Yeah, no, the experiments in his basement are not the proper methodology for testimony about how long it takes paint to dry. The subject matter of the proposed testimony of Mr. Gilman, as described in his certified weather statement report dated February 3rd, 2025, is the condition, particularly the hardness of the ground in the lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29th of 2022. See the affidavit of Robert Alessi attached here too. And Mr. Gilman's report. An expert witness is not permitted to testify to matters beyond his or her area of expertise or competence. See Rintala. And then somebody said, and is giving David the credit for this, great point, David Ferraro Jr. or Ferrario. If it could break John's head, it certainly should have broken his phone. Yes, Bex, yes, that's what he wants to testify to, this weatherman. How hard the ground is, Bex. Yep, you heard it. That's what they want him to come in for. Oh, and Boozy Beauty is here. Boozy Beauty. Boozy Beauty is new to YouTube. She's been on TikTok for a long time. Very successful over there. She's now posting on YouTube. Go follow her. She's got a great timeline. I posted that timeline, by the way. Boozy, I hope you're cool with that. I posted the link to that in the video that I did, I think, on Saturday. because you did a great timeline of everything that happened in the hearing last week with regard to the ARCA experts and things and stuff like that. And so it's done. It's there. Go give her a sub. She's funny. She's got some snarky videos about what's going on here, and she does her research. So there's that. Moving on. An expert witness is not permitted to testify to matters beyond his or her area of expertise or competence. Mr. Gilman received a Bachelor of Science degree in meteorology from Pennsylvania State University, yay, Penn State, in 1979. Mr. Gilman's CV lists 7 different work experiences, including his current roles as chief meteorologist for precision weather forecasting and New England Weather Sciences, positions he has held since 1980. None of the information contained within Mr. Gilman's CV pertains to the fields of geology, hydrology, or any other relevant scientific field related to the study of the ground in any sense, especially not the hardness of the ground. In fact, none of the information contained within any of the documents provided by the Commonwealth about Mr. Gilman's professional experience relates in any way to expertise on the subjects of determining the hardness of the ground. I love how he keeps repeating hardness of the ground. I know so many of you love Bobby Alessi. We've been calling him Bobby. Somebody even has the username Amor of Alessi, and many of you are crushing on him and his expertise and intelligence, and there it is. The report where Mr. Gilman opines that the ground in the, quote, lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, 29th, 2022 was, quote, hard as a rock due to the frost below. You can't make that up. That's what his report says. His report says that the ground in the lawn area of 34 Fairview Road was hard as a rock due to the frost below. That report is signed at the bottom by Mr. Gilman as a certified weather report, notably not a report on the hardness of the ground. Well, I think that's just one of the problems with it, but I'm sure there's more. This is a cold read for me. As you can see, it's not redlined yet, so we're in it together for the first time. He's good for Fiery Monday. It is a Fiery Monday. Mr. Gilman wrote his report and apparently intends to testify in his capacity as a meteorologist, not as an expert of the relevant science of geology or hydrogeology, to determine the hardness of the ground. Accordingly, as the Commonwealth has failed to meet its burden to show that Mr. Gilman, quote, is qualified as an expert by knowledge, skill, experience, training, or education, end quote, on the science of determining the hardness of the ground, he must be excluded from testifying on this topic at trial. Just when you thought you'd seen it all. We haven't seen his report because it wasn't attached in the public filings, but I thought he was going to come in and testify about the weather. 10,000 maniacs about the weather. Maybe they wouldn't need every other witness to say that it was snowing. But apparently, he also wants to testify about the hardness of the ground. And I think we did realize that during the initial exchange, perhaps. Point 2. The Commonwealth fails to and cannot meet its burden that Mr. Gilman's methodology is reliable. In order to meet its Daubert-Lanigan burden, the Commonwealth must show that Mr. Gilman's proposed testimony is the product of reliable principles and methods, and that Mr. Gilman has reliably applied the principles and methods to the facts of the case. And that is according to the Massachusetts Rules of Evidence. The existence of the requirement to show that a proposed expert's testimony is the product of a reliable scientific methodology presupposes that there is a methodology to analyze. Mr. Gilman's report is devoid of any substance, which could even be liberally construed as a methodology of any kind for reaching his conclusion related to the condition of the ground. The full extent of the information on the subject of the condition of the ground in the lawn area of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29th, 2022, from all of the materials provided by the Commonwealth related to Mr. Gilman is as follows. Quote, the typical lawn area would have been hard as a rock due to frost below and freezing of soil. And that's in there in Gilman's report. I'm sure that he had such a great time writing this too, because it seems to me that Alessi's forte, at least one of them, is with regard to expert witnesses. And when we went over his initial bio anyway on the website for the big white shoe firm that he's a partner in New York, I think that has worldwide offices. He has a lot of experience in environmental law and civil litigation. And I've told you before, I'm a civil litigator too. We just have more experience with expert witnesses than criminal defense attorneys do, because we call expert witnesses, many of them oftentimes, in every civil case. And so we have a lot of experience with accident reconstructionists, biomechanical engineers, medical experts, weather experts, you name it, engineering experts with regard to products liability cases, biomechanical engineers, I think I said that already, and other types, and automotive experts, people who can come in and testify about defects in automobiles, braking systems, airbag defects, recalls on motor vehicles, forensics. And so this seems to be what he's focusing on, and it seems to be what his forte is. And you can just tell here, in my opinion, he was probably laughing when he was reading this. And Team Brittany says, when the crime scene was speaking to all the investigators, did the ground at any point yell out, hey, it's hard as a rock down here? Maybe. I don't know. I wonder if Trooper Paul would say that. I told you the crime scene just spoke to me. It speaks to me. And that's what it said. It said, told me what happened. And there's that. No, Ashley, come on now. Ashley says, did they take a ground or soil sample from that night that has been kept in a state of hardness to test? Come on. They didn't even hardly collect all the blood. I mean, they picked it up. They put the blood in solo cups, but they didn't test it. They didn't even test like all the other DNA that was found in what we assume are the blood stains, the brown red stains on the jeans of Officer O'Keefe. There were 2 male contributors to that DNA. They never tested that. I mean, they didn't even take tissue samples of John O'Keefe's arm, to test for any sort of canine DNA or any sort of, things or other stuff that could have been in those wounds on his arm. So soil sample now, come on, girl, you're dreaming. And then she says, otherwise, how can it ever be accurate based on a different time? You know that I'm joking with you, right? I'm not calling you out. Because I know that was rhetorical, because we know how ridiculous it is. Yes, they had to use a leaf blower, so it's all gone. It's all gone. Boozy Beauty, Boozey Beauty. Thank you for asking. Things and stuff. Yeah, things and stuff. Stuff and things. There's that. Yes. Thank you, Aaron, for pointing this out for all my hockey fans. I mean, the Rangers are having a bad season, but whatever. Not my fault. I know you're Bruins fans, so I'll help you root for the Bruins into playoffs, and then, we'll see. Aaron says, even ice on a hockey rink isn't hard enough to cause head injuries like that. Nurse Kim said his brain was exposed. I've never seen a figure skater fail a triple axel and crack their skull open. Yeah, and we've seen it too. We've seen a lot of ice skaters fall, right? They don't wear helmets like hockey players do. It's a lot of force especially when they're dancing couples, pairs, figure skating, and somebody gets thrown up into the air and maybe lands on their head. We've never seen a skull crack, and that's ice. So there's that. I know you heard Nurse Kim talk about it. I don't know. I can't confirm or deny whether that is absolutely true. So let's not spread the misinformation. I don't know if it's true or not, whether his brain was exposed. I don't know if that's true or not. So that somebody said that they overheard Nurse Kim say that, or maybe Nurse Kim or whatever. Let's not say that it's true, because I don't remember like the medical examiner saying that or Renee Stonebridge saying that right now off the top of my head. It may be true, but maybe it's not exactly true. I'm not sure. However, I'm sure that Renee Stonebridge, the medical expert for the Commonwealth, had to cut into the brain when she was examining it. We got to go back and watch her testimony one of these days. Yeah, he did have a hole in the back of his head. A hole, big laceration, giant open gaping wound. Could you see his brain? I don't know, but let's not go out on that tangent right now. Ice hanky. Ice hanky. I don't think there was any frostbite. Thomas T says ice hanky. I don't think there was any frostbite, but hypothermia. Okay. Moving on from that. As the proponent of the claimed evidence, the Commonwealth must prove by a reasonable, not reasonable. The Commonwealth must prove by a preponderance of the evidence that Mr. Gilman's methods and processes behind his opinions are scientifically reliable. The Commonwealth induced defect with the application of this legal principle to the present facts is that Mr. Gilman has no method or process behind his bare opinion that even hints at scientific reliability. His bare opinion. A proposed expert's opinion should be disregarded where it amounts to no more than mere speculation or a guess from subordinate facts that do not give adequate support to the conclusion reached. The opinion of a proposed expert must be based on more than conjecture, surmise, and speculation, else it should be excluded. Quoting Ducharme v. Hyundai, citing Lanigan and Daubert. Mr. Gilman's opinion that the ground was, quote, hard as a rock cannot be reasonably viewed as anything other than mere unsupported speculation and a subjective belief. For these reasons alone, the court must, as a matter of law, fail to qualify Mr. Gilman as an expert. And note also that if it's a matter of law, there does not need to be a Daubert-Lanigan hearing. A matter of law is something the judge should be able to decide on her own. But Norfolk County. Beyond failing to describe any semblance of a methodology in any of these submitted materials, the Commonwealth and Mr. Gilman failed to show that Mr. Gilman's methodology, or lack thereof, is, quote, generally accepted by the relevant scientific community, is the subject of peer review, or a reasonable application of the purported methodology to the facts, conditions, and data of the particular instance. Remarkably, neither the Commonwealth nor Mr. Gilman ever used the words generally accepted in any of the submitted materials. Oh my gosh, do you remember when Hank Brennan, during the Daubert hearing of Dr. Russell, asked her if her opinion in this case had been peer reviewed? Is that, do you remember that? Right? That was funny. Smurfana says, since I know people monitor chat and your channel, unless he has a degree in civil engineering, geotechnical engineering, or structural engineering for these, quote, findings, yes, he should not be able to testify as an expert. I agree with you. Well done. Well done. Okay, moving on. Additionally, Mr. Gilman does not meet, let alone discuss, any of the 5 Daubert-Lanigan factors required to demonstrate the proposed methodology's reliability. See Commonwealth v. Polk, Commonwealth v. Barbosa. The scant material provided on the topic of ground hardness is unscientific on its face. Also, the inclusion of quotation marks around Mr. Gilman's description of the ground as, quote, hard as a rock is a tacit admission that this analysis is not scientific in and of itself. Well done. Quote, hard as a rock is not scientific analysis. It is a euphemism and a common figure of everyday speech. The use of lay language where a scientific assessment should be extant is a further showing that Mr. Gilman did not rely upon a scientific methodology to reach his speculative opinion. For these reasons, Dr. Gilman's failure to proffer a reliable methodology, or any methodology at all, on the topic of the supposed hardness of the ground precludes the Commonwealth from meeting the methodology prong of the Daubert-Lanigan inquiry. Conclusion. Mr. Gilman is not qualified to render an opinion on the hardness of the ground and in and around the area of 34 Fairview Road in Canton, Massachusetts on the evening of January 28th, 2022, and the morning of January 29th, 2022. In addition, Mr. Gilman has not proffered a methodology, let alone a reliable methodology, in support of his opinion on such hardness. For these reasons, and for the other reasons stated above, the defense respectfully moves this court to exclude the testimony of Mr. Gilman concerning the hardness of the ground in and around the area of 34 Fairview Road in Canton, Massachusetts on the evening of January 28th, 2022, and the morning of January 29th, 2022, on the papers and without the need for an evidentiary hearing. In the alternative, should the court not grant the defense's motion on the papers to exclude Mr. Gilman on his lack of qualifications and his lack of a methodology or reliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the ground hardness testimony of Mr. Gilman. XOXO, respectfully submitted, Robert Alessi, Esquire, DLA Piper, New York, New York. Alan Jackson, Elizabeth Little, David Yannetti, Ian Henshey, dated February 21st, 2025. So this was dated Friday. It was stamped into the court computer and scanned in today. Affidavit of service. He indicates that there's also his affidavit attached to this. I don't have a copy of it. This is docket number 515. The next one that I have is 516, and it is something else. So it may have been attached as an exhibit and we just don't have it. But Robert Alessi knows that's the way we do things anyway in New York. And you submit an affidavit of an attorney or another witness with personal knowledge when you file motions. That's how we do it in New York. Hank Brennan doesn't usually do it. So there's that. We're waiting for the motion to dismiss. We know that it was filed. We imagine that it was filed on Friday. We know that we have a motion right now to impound certain portions of it made by the defense. And so it may, when it comes out, it may be partially redacted or partially impounded. Hopefully the whole thing is not impounded, but we don't know a copy yet. So there's that. Back to the chat for a moment. The whole world calls me Hank is here this morning. Good morning. And says, good morning. Can they appeal any of this? Well, it depends on any of what, they can. Yes. The answer is yes, they can. Yes, they can. Will they, to further delay all of this stuff? I don't know. Will they do a motion to reconsider? Because that's another option. You can move the court to reconsider their previous opinion about, I think this whole impeachment thing is nonsense. I think it's wildly unfair to the defendant, right? So you're giving them your smoking gun in advance so that they can put out your smoking gun. It makes no sense. I don't know what other jurisdictions do this. I don't know that it's judicial discretion. Is it in the Massachusetts rules? It's wild to me that they should have to turn over their impeachment evidence ahead of time to the other side. There are certain things that are mandatorily disclosed in New York. We can go over the New York rule if you want at some point, but that ain't one of them. Turning over your impeachment evidence. It's wild to me. The whole world calls me Hank. Thank you so much for your 20. The answer is yes. Yes, they can. Linda, thanks for gifting a membership. Ron L became a new member. Welcome, welcome. I think you're going to like it here. Parachutes and Pirouettes is coming in with a Canadian 5 and says, good morning. Thank you for catching up on Rewind and also for your super chat and for watching from Canada. This is a worldwide story. Guys, tell us where you're watching from if you're outside the U.S. or even if you're inside the U.S. Put in the chat where you're watching from. Resisting Arrest became a member. Thank you so much for joining us. Love to have you. Lori Joyce, could Ronnie the juror be subpoenaed for the habeas proceedings? I asked because of potential jury tampering by the foreman. Not the habeas proceedings as they currently stand, because they don't listen, they don't subpoena witnesses and they don't talk to witnesses and they don't call witnesses. This is an appellate procedure that is, as Kurt explained, it's a collateral procedure. They're not technically appealing from the state court to the federal court. It's a sort of like a, what did you call it, Kurt? I don't know if you're still here. It's a lateral proceeding. So They don't subpoena witnesses. They don't talk to witnesses. They don't call witnesses. It's something that is done on papers and oral argument as a question of law. So great question. Answer is no. Michelle, thank you so much for the 5. Love the show. I watch all the time. Did you read the petition for habeas corpus? Yes. Yeah, it's 35 pages. We talked about it the other day, Michelle, and there was really, as far as I could tell, no new arguments in that. We've been over at length all of the appeals of the appellate brief that went up to the SJC, and it's all basically the same double jeopardy arguments. And so there was really nothing new in there. There wasn't anything with regard to jury tampering or any federal things like that. So I didn't feel the need to read it on the air. It's 700 pages, but 35 of it is the brief. And the other, however many pages, adding up to 700 and something, is the record on appeal and other attachments. So while it is, of course, interesting, the double jeopardy issue, it is not drastically different in any way from the appeal that went up to the SJC, in my opinion. But again, I'm not an appellate attorney or constitutional attorney specializing in constitutional law, but I am a constitutionalist. I think that we should give everyone in the United States the federal rights that they are owed under our Constitution of the United States of America, because, you know, it's one of the things that makes us great, right? Dr. Russell's the GOAT is here from Norway, by the way. It says, you and others speaking about this case is jury tampering, but not the hostage video by Marcy. Who did they say I'm jury tampering? Oh, no, they said that Turtle Boy is jury tampering. And I think they had some video clips of him like saying stuff in a bullhorn, not even stuff that he does like on the YouTube. Not the hostage video by Marcy. Sure. Yeah. Well, I mean, you know, look what we're dealing with. Dr. Russell is the GOAT. Joe Bream or Joby Ream. Thanks for the 10 and thanking you for thanking me and appreciating me and for covering these motions so quickly. And I appreciate you just as much, if not more than you appreciate me. So thank you. Carmel McPartland became a member. Welcome. Fire on Acid is here. I assume this is strategy by not bringing this up to the judge, Fanning, and the jury, I mean. Well, we haven't seen the motion to dismiss yet. Could it be in the motion to dismiss? Probably. I would imagine. I mean, it was put out there in the interview with Ted Daniel. So we haven't seen that yet. We're still waiting. So stay tuned. Fire on Acid. Stay tuned. Sage Henning is here, says, look the other way. Plevin is on that also. He said the federal investigation is over. The witnesses were called on a Sunday and we're told it was over. Yeah, because that's what they do. That's what they do. They call you and tell you it's over. Don't worry. No worries. No worries. We're done with our investigation. No worries. You're in the clear. Yeah, I don't know what's going on over there, Sage. I don't pay attention to Twitter. Little Miss Red Velvet, OG. Thank you for gifting 5 memberships. Appreciate you. Lisa C says the best part of the year gone by is me. Thank you for being with me for 12 months, Lisa. I appreciate you so much. Chastity gifted a membership. Thank you, Chastity. Appreciate you so. Kimberly's here. Thank you for your super sticker. AJ's full-throated motion, which you're still waiting for. Hardness has entered the chat. Thanks, girl, for your deuce. Ms. Stone is here. Excited to spend the morning with me. Thank you. I'm excited to spend the morning with you too. Fairy Raven Emma is here, and it's your birthday. Happy birthday, Emma. Emma's from Ireland. She's amazing. She says, Spicy Melanie is my favorite birthday present today. I don't even want cake. How about a cupcake? Cupcakes for Emma today, everyone. Happy birthday, Emma. Hope you have an amazing day and an amazing year ahead. Andrea says, I live in Utah, and I would assume that anyone that lives where it snows knows that it is less hard when a snowstorm is coming in. Well done, Andrea. I think a lot of people don't know that. That's why the Commonwealth is spending your money on a witness to come in and testify as to the hardness of the ground. And apparently, I think he was a weatherman, right? He was a weatherman. So, Andrea, love Utah. Spent a lot of time in Park City, my college years, skiing out there. And yeah, I don't think, you would think, but people don't know. That expert doesn't know, but thanks, Andrea, for telling us. Debbie is here with a $20 super sticker. Thank you, Debbie. I appreciate you. Amy's Positive Pathways is here. We're going to try and be positive today, Amy. Commonwealth seems to be reaching with experts, cannot get actual experts to testify. And we learned also in the papers that we went over on Saturday that Commonwealth intends to call Dr. Crosby, the canine aggression behavioral specialist who doesn't have a medical, he's not a medical doctor, he doesn't have a medical degree. They only intend to call him on rebuttal. And it's like, maybe we'll call him on rebuttal. So, you don't really need a Daubert hearing because, maybe we're going to call him. But in the last trial, the judge clearly said that Dr. Rentschler could not testify as to his opinions of the causation of the injuries to John O'Keefe, because Dr. Rentschler's opinion was those injuries were not caused by a car accident, and those damages to the car were not caused by hitting a pedestrian. And the judge said, no, he can't testify on that because he's not a medical doctor. You think she's going to overrule herself and say, yeah, well, Crosby can testify. But that's right. They don't have a medical doctor who's going to come in and say those injuries are not caused by a dog, but they have a canine aggression specialist who's not a medical. Yeah, it makes no sense. Make it make sense. Make it make sense. Susan's here. I pulled the weather in January. It was 43. 5 days before, it was a very warm January. The ground was not frozen. I don't know. I don't know whether it was frozen or not. I'm not a geologist or whatever specialty you need to be. Thank you for pulling those weather records. Unfortunately, they can't call you as an expert either. Thank you for your 5. Nikki, wouldn't a frozen solid ground mean that John would have even more bruises and injuries? It's going to backfire on the Commonwealth. I don't think it's going to backfire on them because I don't think he's going to be allowed to testify to that. So, yeah, make it make sense. It doesn't. You can't. You cannot make it make sense because it just doesn't make sense. It just doesn't. Kyle is here. Says regarding Microdot's tale of 2 searches. Yeah, if you don't follow Microdots on YouTube, do that as well. Richie makes amazing videos about this case. And that's an older one, right? After watching, I'm convinced the leaf blower wasn't a search tool. It was to obliterate signs of his placement. You mean like footsteps and stuff and drag marks? Interesting. Interesting. Shout out to Microdots. Thanks, Kyle. Fancy RPG is here from Canada and says, number 1, you keep calling these droppings and it makes me giggle every time. Yeah, because, ducks, droppings, much of it is, poop-like. So, it seems fitting. And it makes me, my dream stream is of you and Emily Baker geeking out over Dave Matthews. Wouldn't that be amazing? I don't have a direct line to Emily. I wish I did. I've emailed her, but I'm sure she's very busy. But if anybody else does, I'm down for it. I would love to. I'm a big fan. I've been watching Emily before I ever had a channel. Watched her during the Johnny Depp and Amber Heard stuff. And that was fun to watch her. She's amazing. What the Duck says, I know, call me crazy, but let's just think logically here. Well, come on, really? Even if he fell into the back of his head on the ground, how could that cause injuries on both sides of his head as well? Right. Yes. Temporal injuries on both temples, because, that's why they're called temporal injuries, right? Because they're, and, the fractures in the front of the skull, the brain bleeds here, there, and everywhere. Make it make sense. I can't. I wish I could, but thank you for the super chat. Emma's here and gifted a member. I mean, why are you giving out gifts on your birthday? We should be giving you gifts like cupcakes. Ann Smith is here. Melanie, would just the way the evidence was collected and the inverted video make a normal judge dismiss the case? Let's wait and see the motion to dismiss. What I have is I do have the order from the first trial, from the motion to dismiss. And a lot of you are not familiar with all of the pretrial proceedings that happened. Oh, that's funny. I am talking to Runkle actually about doing something. I saw that go by in the chat. Full melt hash value says, Melanie and Runkle, please. I am in touch with him and he's totally down. So we're going to try and plan something. Would it make a normal judge dismiss the case? There's so many issues here. So many issues. What's normal in the world of judges? There is no normal. Would it be excluded from the trial? Yeah, but remember that trial, that video was turned over in the middle of trial. And nobody seems to know where it came from. And the Commonwealth does not want to turn over any logs or metadata or chain of custody or evidence about where all of these videos came from, because we heard Hank Brennan argue that in open court. We should not have to create logs where they don't exist. Well, okay, but how are we going to find out then? I don't know. The more and more I think about it, the more and more I think about that Lally is going to be called as a witness. Maybe that's why he's just sitting there saying nothing, because how did Lally come into possession of that inverted video? Didn't Buchanan say he doesn't know? He doesn't know how he got it. Nobody knows how they got it. It's going to be crazy. It's wild. Chain of custody is supposed to be a thing. Authentication of evidence is supposed to be a thing. Best evidence is a rule I learned in law school. And so this is just crazy on so many levels that it's hard. Hard is the ground. It is hard to even figure out what we're doing here and how so much of this stuff is allowed. Because in Massachusetts, it seems to be, well, I'm not going to exclude it, but it's just going to go to the weight of the evidence, and not its admissibility on the one hand. But on the other hand, if you have any impeachment evidence that you want to use on cross to discredit this evidence, then you need to turn it over to them ahead of time. Okay, what? That makes no sense. So if the defense knew this inverted video was coming, for example, right, because they were notified or it was exchanged ahead of time, and then they had a way to impeach Yuri Buchanan about the fact that he didn't know where that evidence came from. Maybe let's say they had, just for example, this is an example, this is not true. Let's say they had video of somebody handing Yuri Buchanan that exact evidence to bring to court or whatever. The defense would have had to turn that over to the Commonwealth ahead of time so that Buchanan would have been prepared for the impeachment that, yes, in fact, he should know where he got it from because we have video of you being handed it. Do you see what I'm saying? It makes no sense. I don't remember if he said exactly that he got it from Rafferty, but I'm just using that kind of as a hypothetical example. But thank you, Nosy Rosie. But I don't remember that exactly. Maybe he said the chief told me this, or the chief told, like, whatever. Could have been hearsay. It makes sense. It just doesn't make sense. The video came from Rafferty, but did she give it to Yuri, or did she give it to Lally, or did she give it to someone else? Like, who did she give it to? That's what they want to know, and they're entitled to know that. Where did this video come from? Why do you keep turning it over piecemeal? Why are we just now getting video last week of Karen's car backing up into the Sally Port from January 29th? When you've had it clearly all along. She gave it to Tully, who gave it to who, though? See what I'm saying? Thanks, Dina. I appreciate that. You guys are so collaborative, and I love that. Using that as an example, Tully gave it to Proctor, but we don't really know, right? Because there's no logs, there's no evidence logs, there's no chain of custody logs, there's no metadata. It's just not important here. It's just not important. And that's what they're telling everybody, that this stuff isn't important. It just isn't. Right? Nobody knows nothing about nothing. So Ann Smith, thank you for your super chat. Mrs. Bouquet, thank you for your super sticker. Appreciate you. Michelle Fannin, thank you for hanging out for 8 months and for thanking me for keeping the facts straight. Appreciate you. Tracy Davis, thank you so much for your super sticker. You guys are here and you're so kind and generous this morning. Kay Willis is here. She's a realtor south of Boston for your real estate needs and has gifted 5 memberships. Thank you so much, Kay Willis, for being so kind and generous. And so many new members today. Welcome, welcome, welcome. All right, let's take a look now at docket number 516. Docket number 516 would just hit the presses this morning around a little before 9 o'clock. I don't know. I guess the clerk's office must open at 8:30 because it's dated 8:50. I mean, it's stamped 8:50 something this morning. And it is called Defendant Karen Reed's motion to impound portions of the defendant's motion to dismiss for extraordinary governmental misconduct. All right. 516, docket number 516, and here we go. Let me just make sure everything is set the way I like it. Red pen, ready. Here we go. Defending Karen Reed's motion to impound portions of the defendant's motion to dismiss for extraordinary governmental misconduct. Remember, the deadline for that was Friday, the 21st, according to the new briefing schedule or the new trial schedule, scheduling order, whatever they call it in Massachusetts. God save the Commonwealth. Now comes the defendant, Karen Reed. Ms. Reed, and respectfully moves this honorable court for an order impounding portions of defendant's motion to dismiss for extraordinary governmental misconduct. Affidavit of Alan Jackson filed in support thereof. So it's been filed. There you go. There's your proof that it was filed. We just don't have it, and it's not inserted or typed into the court docket yet. And supporting exhibits, namely the portions of the filings that are subject to a protective order, including, number one, reference to information that is subject to a federal protective order. Number two, sidebar transcripts, which remain impounded. Number three, communications obtained from law enforcement witnesses that are subject to a protective order. Okay. So if portions of this motion that we eventually, hopefully will see, if she doesn't decide to impound the whole entire thing, that are redacted may indeed relate to these three topics, including information subject to a federal protective order, sidebar transcripts, and any communications obtained from law enforcement witnesses subject to a protective order, like Michael Proctor's text messages, like text messages between Yuri Buchanek and Chris Albert, or Yuri Buchanek and other people, like text messages between Tully. Because we know in Aidan Carney's case, there were some text message threads between Tully, Mello, Mafia masshole Kate Peter, and Lindsay Gattani. And those were requested also, I believe, in this case. So there may be some things and stuff, some communications obtained from Tully and or many other law enforcement witnesses in this case. Good cause exists for the impoundment of these portions of the motion because these materials and exhibits are, number one, subject to a federal protective order issued by the U.S. District Court for the District of Massachusetts, and two, subject to protective orders issued by this court, period. In support of this request, Ms. Reed hereby submits, one, an unredacted copy of defendant's motion to dismiss, an affidavit of Alan Jackson, Esquire, and supporting exhibits for the court file, and number two, a redacted copy of defendant's motion to dismiss, affidavit of Alan Jackson, and supporting exhibits with all information subject to protective order redacted for dissemination to the public. Wow, look at them. They did the work. They did the work. It doesn't cost anything to hit the thumbs up. You're right. Thank you. Thank you so very much, AM. Helps push the stream out, helps get the information out there. And a lot of people may not want you to know about this case and what's going on in this case. And in fact, the Commonwealth, the prosecution led by Special Assistant District Attorney, or Special whatever they're calling him, hired from outside the office of the Norfolk District Attorney's office by Michael Marcy, your district attorney, even though there's no conflict, because it's the hot potato case of Norfolk County, and none of the 50 other attorneys who are actually employed by the Norfolk County District Attorney's Office apparently want to try the re-persecution case. Okay, Fran McDonald, I don't tolerate bashing of people in my chat. That's being deleted. That is your warning. Maybe the mods probably already took care of it. It just happens to be that I'm frozen here. I'm behind on the chat. That made me lose my train of thought. However, the Commonwealth has moved the court to impound everything going forward filed by the defense so that the Commonwealth and the judge can determine whether or not portions of it should be impounded, because Hank Brennan now wants to police the defense. We looked at that motion the other day. We may pull it up again just for fun, because that's what he wants the judge to do. So you're going to police the defense filings now? You want to be the one to determine whether or not portions of it should be impounded, because why? It's wild. XOXO. Alan Jackson, Elizabeth Little, David Yannetti, Robert Alessi. This was signed by Elizabeth Little. So they did the work for the court. They submitted a redacted copy and an unredacted copy. And they said, that's a courtesy. They didn't have to do that. It does speed things up with regard to getting it on the docket, because once the judge approves it and says, okay, I'm approving this redacted copy, then they can just put it on the docket. And maybe, just maybe, we will get a hold of it while we're here, right? Maybe, but if we don't, we'll come back later. Or as soon as we get it, because tomorrow is the hearing at 11 a.m. And hopefully we will be able to see it before then. They're not going to discuss the motion to dismiss tomorrow or argue it, but everyone's waiting on the edge of their seat to hear it. I know you are. I am too. Thank you, Lynn, very much for your Venmo, just for thanking me. I appreciate you so. Jody617, thank you so much. I don't know why you're blocked from the chat. It may be may have been a mistake, but thank you for your Venmo. I cannot look at that right now because in order to do that, I have to go through hundreds and hundreds and hundreds of names. So I will try and take a look for that later. Justin, thank you so much. Says he hopes that AJ gets the sweetest revenge tomorrow. Thank you, Justin. I appreciate you. All right. Moving on to the affidavit of Elizabeth Little in support of this motion, because that's the way it's supposed to be done. That is the way it's supposed to be done. Sometimes what happens is when there's over 7,677 people in the chat, which there is right now, the chat goes by so fast. Sometimes if you're on your phone, because you oftentimes click on the wrong thing on your phone, it could happen that you get timed out or deleted or something like in error. So apologies, but nothing I could do about it in the middle of my stream to correct. Okay. Think of Paul's Cord hand signs for gifting 5 memberships. If you know, you know. If you know, you know. No talk of Krispy Kreme, please, in the chat, because, we try and keep it clean here. Thank you so much for your gifting, and to those 5 new members, welcome. Veronica M became a member. Welcome. Carmel, thank you for your super sticker. Piney Woods, thank you for your 20. Thank you for your 20. Says all defendants are entitled to procedural and substantive due process. Ms. Reed has been denied both. Yes, you are correct. I agree with you. I'll allow it. I cannot explain the judge, but she should be removed. Well, I also have the old order of her not recusing herself. We can go through that as well. If we have nothing new to go over, then you guys are interested in it. That is an old order. We watched the hearing together, and she ruled from the bench that she would not recuse herself. But there was a subsequent written order that we didn't have time to go over because the trial started, and for whatever reason, I guess I never went over it because I have a copy of it now. Yeah, let's just not even talk about Paul. I don't know why I just got an itch. Okay, so yes, I look, are they going to make another motion to recuse her? I don't know. Could they? What I also thought was interesting, and for those of you who are interested in looking up case law, you might want to look this up, that in the motion, in the order that she rendered to not recuse herself, she cites the case of In re Bulger, Whitey Bulger. But in that case, the judge actually did recuse himself just because of the appearance of impropriety, I believe. And so I found that interesting that she cited that case in her decision not to recuse herself. I found it interesting also because it was the Whitey Bulger case, and now we've got Hank Brennan tag teaming in for the prosecution when he was one of the attorneys representing Whitey Bulger all the way back then in the early, I don't know, it was like 2013, I think, that decision in Ray Bulger. And I said when we were going over that motion to recuse, even the appearance of impropriety is improper, right? That the judge had the opportunity to recuse herself from this case, to get away from it, to say goodbye. And her decision, her reasoning could have been, look, I don't know the McCabe's. I don't know Sean McCabe. I don't know why he allegedly told this blogger that he was going to bury him under my seaside cottage. I don't know why there's a Venmo payment from Julie Nagel to Ryan Nagel that says for Frank and Beverly in the description box. because my name is not even spelled Beverly that way, but my husband's name is Frank, coincidentally. But in the interest of avoiding the appearance of impropriety, I'm going to step away from this case, and another judge should hear it. Even though I don't know these people and none of this is true, I could have. It could look to an outside observer that I am, oh no, Al Troutwig died. Those of you who know. Al Troutwig, longtime voice of the MSG network, at 68. He's only 68? Oh, that's breaking news in the New York Post. That's sad. I met him once in Penn Station. Oh. All right. Sorry. She could have recused herself because somebody looking at this case from the outside could say, all of this stuff is a little bit sus, and maybe you should avoid the appearance of impropriety, and therefore you should step away from the Karen Reed case because you might know some of the witnesses, or some of the witnesses are saying that they know you. They are claiming that they have a house near yours in the Cape and you share the same beach access, but she didn't. So that could be an interesting thing for us to go over today, that old order. Roberta Flack also passed away, Michael. All right, things usually celebrity deaths happened in threes. This is so interesting too, because I know this is the way that some of you guys in Massachusetts talk. So didn't Roberta Flack, but that is a Boston thing, and I know it because so many of my friends are from Boston, and when we were kids, they'd be like, so didn't I. I think Hank Brennan actually said that in court one time recently, like so didn't, or that, but he really meant did. Not throwing shade on you in any way, shape, or form. I just know it's a regional thing. And I thought it was interesting that Hank Brennan, I think, said that one day. I don't have the actual clip pulled up, but she could have, but she didn't. Right? All right. Now, moving on to the affidavit of Elizabeth Little in support of impounding portions of defendant's motion to dismiss for extraordinary governmental misconduct. We know that motion was filed. We don't have it yet. This is docket number 517. Docket number 517. Let me just see if there are any gaps here, and we can file 11. No, I don't see any gap in numbering. So it's not that the motion was filed and we just don't have access to it yet, or it was numbered and they just didn't put it into the system. It's that it's just not there yet. Sometimes if you refresh, it helps. Hold, please. Talk amongst yourselves for a second. Talk amongst yourselves. A little coffee talk. Sweater weather. It is sweater weather. No, nothing yet. Okay. I, Elizabeth Little, do hereby depose and state that the following is true to the best of my knowledge and belief. See how she doesn't say, my name is Elizabeth Little. There's my little name tag at the top that says, hello, my name is Hank Brennan. Because I would comment every time I would read one of his motions where he says, my name is Hank Brennan. And yet it sounds like he's at a sales conference with a red sticky name tag on his lapel of his suit. And it says Brennan because his paralegal, or whoever does his typing, wrote his name as Brennan one day. And we caught it, but he didn't. Okay. I represent Karen Reed, the defendant, regarding the above captioned matter pro hoc vice. Good cause exists to file portions of defendant's motion to dismiss for extraordinary governmental misconduct, supporting affidavit of Alan Jackson and supporting exhibits, namely all references to impounded sidebar transcripts, references and information that is subject to a federal protective order, and communications obtained from law enforcement witnesses that are subject to a protective order under order of impoundment, because this court and the U.S. District Court for the District of Massachusetts have issued protective orders concerning this information. Signed under the pains and penalties of perjury, because that's the way they do it in Massachusetts, 21st of September, Elizabeth Little, XOXO. the certificate of service. And that is docket number 517, which is the most recent thing showing up on the docket. Back to the chat. Lori Joyce, thanks for the 5 follow-up question, please. Who would hear in the court system about jury tampering then? Well, it would be, if it was brought up in a motion to dismiss, it would be in front of Judge Cannone. If it was brought up in the motion to dismiss, depends on where it's brought. So it is the trial judge who hears all of the pretrial motions and motions regarding things that go on during the course of the case. So that is the answer to your question. Rescue puppy, shouldn't the DUI be tossed because no ticket for DUI? There's no straight up DUI charge. It's DUI with regard to a motor vehicle accident. I never thought any of that blood extrapolation evidence should have been allowed in because even the Commonwealth's own witness says it wasn't reliable. That's not why they do that testing. That specific testing is not done to be used in court because remember they did I can't remember exactly, but it was a blood serum level that they ran in the hospital secondary to her admission on a section, right? An involuntary hold because allegedly she had been threatening to take her own life or something. She was not brought in to the hospital for purposes of DUI, for purposes of MSP blood testing. It's not the same test. It's a serum test. They extrapolated it. There was no evidence of when her last drink was. None of it should have been allowed in my opinion. But again, this is where we are. Many motions were made prior to the last trial to keep stuff like that out. And those motions, that motion specifically was denied. It was one of the motions in lemonade before the first trial, which the closed captions called it motion in lemonade one day. So we stuck with that. It's a motion in lemonade. Caroline, best place to be on a Monday afternoon. Thank you for being here. Parachuting matron saint of Karen Reed. Well done. Well done. One of the motions we looked at the other day. Hank Brennan sat in the motion. Dr. Russell parachuted herself into this case. That was wild. And look at you being on top of that username. If Crosby is allowed to testify, and I called her the matron saint of the Karen Reed trial one day. So that was fun. And we've stuck with that. So thank you for, the nod to me and your username. I appreciate it. If Crosby is allowed to testify, then so too can Dr. Rentschler, Free Karen Reed, John O'Keefe. John O'Keefe, thank you so much for your super chat. I caught alive. Yay. Gen X chick is here. Yay. Greg says, unfortunately, I believe the judge and Brennan are going to stack the deck against Karen this time. I don't feel good about this trial too at all. Well, like I like to say, Greg, worry is a wasted emotion because most of the time you're worrying about stuff that already happened. So can't change that. And the other half of the stuff you're worrying about is stuff that may never happen. So let's wait and see what happens. Okay. That's my inspiration of the day. Thanks for your 5. Manic Monday is here. And look, changed his or her username also because of what we were talking about at the top of the stream. Thanking me for my insight. Well, thank you for tuning in because without you guys, I would just be screaming into the closet or yelling at the TV by myself. And there's nothing more fun than being here with you on a Monday morning. Ellen Victoria is here. And she says, I got a gifted membership from Kay Willis, the realtor. Oh, that's awesome. Thank you so much. Thank you, Melanie, for always covering, watching from Denmark. Denmark is here. Norway is here. South Africa is here. Australia is here. Ireland is here. Thank you, Ellen Victoria. And look, see, Juan is here. He's from South Africa. He's here. Loves my show. Free Karen Reed. The world is watching. Thank you. Thank you for your super chats, guys. Mrs. Mark is here. Thanks for your 20. Can't believe it's been a year of watching you. Thanks for all your coverage. Thank you. Thank you so much. There's another Melanie here. We have a lot of Melanies in this chat. A lot of Gen X Melanies, right? And you seem to have a lot of Kirstens, Kristens. And I say, if you're talking to a Gen X woman and you don't know her name, just call her Jennifer because like 80% of the time you're going to be right. Says, I watched your videos on the Michael Morrissey letters. In his first letter, he mentions the Bulger case. Yes, he does. I brought that up the other day. Thanks for going back and watching that old stream. I appreciate you. I have an entire Karen Reed pretrial playlist. And I forget how many videos are in it, but it's a lot. Kelly says, if Chloe bit, you must have quit. And says, has there been any opposition or filing yet about Hank choosing to go through Morrissey's phone and emails himself instead of going to a taint team? Nope. Nothing other than what we went over, where he said that he wasn't comfortable. I think he said that in open court using the taint team, and so he wanted to do it himself, or he did do it himself. He's always you notice how he's always patting himself on the back? He's always getting up there, patting. I hope he doesn't like strain his shoulder patting himself on the back so much, but it's like, yes, I'm turning over everything, even random anonymous emails that I get from people. I'm never going to call an anonymous person to the stand, but I'm here to be open and honest and transparent. And so I'm just turning over everything. I'm going above and beyond. I'm doing more and more and more and more than is even required of me because, I'm the new guy and I'm so great. Thank you for pointing that out. We have a lot of Gen Xers here. I think that's my largest demographic. YouTube gives you analytics like you can't even believe. Megan, thanks for the 10, says, celebrate we will, because life is short but sweet for certain. Hey, those are 2 Dave Matthews posters behind me. She knows. Megan knows. Thanks for the 10. So today is my birthday, and I'm so grateful to spend it with you, Melanie. Oh, it's Megan's birthday and Emma's birthday. So cupcakes for Megan and Emma. Happy birthday, girl. Thank you for watching, and thanks for your super chat. Laura Not Croft says, so the taxpayers are paying for Hank, Lally, and McLaughlin. Oh, yes, also Hank's paralegal. Hank has brought his paralegal. She is here, she or he, I'm not sure if it's a she or he. Despite his or her misspellings in many of the motions and grammatical errors and other things, misnaming motions, mistitling them, they're paying her as well, or him. What's the point of them all being there if they're not going to communicate, especially about trial 1.0? I honestly don't get it. I don't know. That's why I kind of think that maybe Lally is kind of sandbagging him. He's like, go ahead, dude, go on with your bad self. Get out there in open court and say that you haven't watched the trial. You don't know anything about what happened at the first trial, but, that's not an excuse. Like, Lally's sitting next to you. He was there. In fact, he examined every single witness. That's a lot of work for one attorney. That's a lot of work. Lally did it all. Lally was like a one-man band. He had cymbals between his knees. He had like an accordion. He had like a harmonica in his mouth. He was a one-man band during trial number 1. He knows everything about it. And now he sits there completely sidelined, dejected. Posture is despicable me-like. I can't even imagine how he feels being dethroned like that and having a new guy come in and just take over. And is he sandbagging him? I don't know. Is he helping? I don't think so. It's crazy. It's weird. Lori, thanks for the 5. I've changed the word worry to wonder, such as I wonder how great Karen will feel when she's acquitted. Well done. Make it a positive. I love it. I love it. Kim loves Labradors. Thanks for the 10. Is thanking me. No, thank you. Thank you. AJ, you want to go over actually, it's the order that I have on the order to recuse. It's old. It's the old one. When she did not recuse herself. It's long, and we can look at it. And I think we should, because maybe we'll glean something. Because, the best way to determine what a judge is going to do is by looking at their prior rulings. At any time, you can quote from a judge's prior rulings in your current motions, as they did during the opposition or the motion to preclude Crosby from testifying. To me, that's fire. That's a fire motion, because you're using the judge's own words against them. And what is the judge going to say? Turn around and say, oh, I was wrong. Now I realize what I said in the last trial, but I was wrong about that. Non-medical doctors should be able to testify about the cause of injuries to a human. I don't think so. Thank you, Carrie, for buying me a matcha latte. Appreciate you. I'm going to need a lot of it today as we still wait. Yes, Roberta Flack died. She was 68. Look at that. Killing Me Softly was her anthem, one of her anthems. Crazy. Well, let's take a look at, also I want to, for those of you who were not here maybe the other day. That was in docket number 504. Hold on, 504. Get that for you. Let's see. This was in the Commonwealth's motion for sanctions That was filed. Let's see when it was filed. It was filed on February 14th. It was one of the motions they did not get to the other day because initially she told David Yannetti asked, you want me to argue both motions at once? And she said yes, but then she said no. And so he didn't go on to the sanctions portion. So they never got to that because the hearing was abruptly cut short due to her grave concerns about, the things that she was told by Hank Brennan, which we now know were not accurate, were not turned over to him by the feds, but the defense, and gave her grave concerns about not only the defense, but the defense attorneys. In his motions for sanctions, one of the things that he asks for is this. Oh, look, I put 2 red arrows there because I liked it so much, and I wanted to talk about it with you today. Again, I'll remind you of this, that this may be why we do not even get to see the motion to dismiss for extraordinary governmental misconduct, because Hank Brennan has asked the court, although she has not ruled on this yet, because you know what? The defense also hasn't had a chance to argue it yet, so she can't just grant this. Now that I'm thinking it through, Therefore, what he says in this page 2 of this motion for sanctions, the Commonwealth moves that the defense be sanctioned to include, but not limited to, being ordered to file all motions under seal and impounded until such time that both the Commonwealth and the court can ensure that the filings comply with all previous orders set by this court. I'm sorry, what? You are going to now police the defense filings and you want the court to order that you have the right to do that? I'm sorry, what? Where are we again? Oh, that's right. We're in the Matrix. The judge can't rule on this because the defense has not had a chance to argue it yet because she cut it off. Yeah, right, exactly. Brennan's pixie dust, aka Noel, says, wait, are the court and the Commonwealth the same gatekeeper? What the duck? Oh, I love that girl. What the duck? Apparently Hank Brennan wants the court to order him the authority to determine whether or not all motions from here on in filed by the defense should be impounded. Because, he's the self-assigned taint team now, apparently, according to what he said in court one day about those messages that he didn't feel comfortable with anybody else looking at. So he took it over and took it upon himself to now be the taint team with regard to, I think, Michael Marcy's emails and communications, because those are fair game now, because Michael Marcy, the district attorney, has emailed a whole bunch of judges in Stoughton from his private email account. So that's all coming in and is being turned over. Not only has he assigned himself to be the taint team, but now he wants to be the gatekeeper. Canton trying to go the Delphi route. Yeah. He thought Delphi was crazy. I can't decide which one is more messed up. But Canton's like, yeah, hold my beer. Hold my beer. We got more. Right? That's what he wants the court to order. And then he says the content of improperly filed motions serves to taint the prospective jury pool. Oh, kind of like how you got up in court last Tuesday, made a whole bunch of misstatements of fact, said that email wasn't dated. Really? She said that there was a paid, I don't know if he said it was a paid bill. He said there was an invoice from ARCA submitted to the defense for $23,950. He didn't say it was paid. He didn't say what the date on it was. Kind of like how you tainted the jury pool by getting up there and letting all that stuff hang out there for a week because the judge didn't give anybody on the defense team an opportunity to respond to that and correct the record. And then you get back on the record after the 30-minute timeout. The judge comes back shaking like a leaf. And then you say, I need to get up and, talk about the chronology of things. Not correct the record. Talk about the chronology of things. And then you still don't give the defense an opportunity to respond in any way. You make it sound like you're making everybody come back a week from now with their own lawyers because you're so gravely concerned about the defense and the defense attorneys and potential ethical violations, and you let that sit out there for a week. Because remember what Mr. Brennan said, a lie unchecked becomes the truth. He said that, and here we are. And I can't wait to see what Alan Jackson has to say about this tomorrow, because you know he comes in with his receipts, and you know that he is going to shred Brennan tomorrow. How dare you get up in open court and accuse another attorney of ethical violations like that, and then get up there to talk about your chronology of events without actually saying you're correcting the record, that the defense actually gave you all of this stuff. Not only did they give you all of this stuff, but when I went back and watched the hearing, I think this is the correct date, they gave it to you on the 13th of February. The defense filed their opposition on the 16th of February. This hearing was on the 18th. You could have put this in writing in a reply, Mr. Brennan. You could have put this in a reply, but you didn't. You chose to get up in open court and accuse the defense attorneys of blatant ethical violations without putting any of it in writing. Isn't that convenient? Isn't that convenient? That was the motion to exclude ARCA. And the defense filed their opposition to that, like I said, on the 16th, after they had turned over all of the stuff that, quite frankly, they weren't even required to turn over yet, because their start date for turning over their reciprocal discovery has not really started. The Commonwealth filed their certificate of compliance, but they're still not done because we looked at another dropping of theirs from the other day. It's all part of the show. It is all part of the show. That's right, Mama. Right. He also said he's lost confidence in communicating with the defense, right? Because his agreements don't really mean anything. Thank you, Karen Cole is here. Karen Cole is here from the UK. She is a lawyer too. And then he also pretty much in open court. This was also wild. All right. So that I just wanted to go over that because that we looked at again the other day, but if you weren't here the other day, you didn't see it. This was from Valentine's Day. Again, in open court, he gets up after the judge says, you know, she hears the pro hoc vice application for Betterow. Well, she really doesn't hear it. She tells Mr. Yannetti, oh, remember, Mr. Yannetti, when you tried to do this for Robert Alessi, and I said, I need more information about why you really need him. And then she said, oh, for Mark Betterow, is that how you pronounce it? Do you think Judge Cannone doesn't know who Mark Betterow is and how to pronounce his name? That was kind of funny. And then she said, you know, Mr. Yannetti, I'm going to need you to, you know, supplement this affidavit. Give me a little more information about why you need him. And Mr. Yannetti said, Judge, are we going to need to have a hearing on this? Or are you just going to, like decide on the papers? And she's like, yeah, I'll likely approve it. I just need more information, you know, as long as I know there's no opposition. And then they start to move on. And that's when Hank Brennan gets up and he's like, she's like, okay, do you have opposition? He's like, well, no, not opposition, but you know, I just want to share some of my thoughts. You want to get up and share you want to share some of your thoughts? You're going to get up. So you have no opposition. You're cool with Mark Betterow coming in as part of the defense team, but now you want to get up in open court and perform for those people on your right? Give them some sound bites, but you don't have any of this in writing and you're not opposing it, but you just want to share your thoughts. Right. That was wild. And then he shares his thoughts. And in his thoughts, he pretty much blatantly accuses Mark Betterow of sharing information with the defense that was under protective order with absolutely zero evidence of that and zero receipts of that. And talks about how Mark Betterow represents Aiden Kearney, you know, he doesn't even pronounce Carney right. And you know, Karen Reed, and they have this agreement and this understanding that they've been sharing information all along that is completely improper. Deep thoughts with Hanky. Yeah. He's talking about this agreement to share information that's under protective order. And they've been doing this the whole time. No receipts, no evidence of that. You know, the court should just be aware, and the court should, you know, could do this, ex parte. The Commonwealth doesn't even need to be there. And you should just do this ex parte and inquire. And, he's like telling the judge what to do, but it's not in writing. And then after he finishes his monologue, like he's in Hamlet or something, she says, oh, Mr. Yannetti, I am going to have to consider all of this stuff that I just heard. What? You're going to consider his monologue, his Shakespearean monologue that he practiced in the mirror for days? It's not in writing. It's not in opposition. But you're going to consider that in your determination of whether to admit Mark Betterow pro hoc vice from New York? What? That is crazy, because we've heard this judge say during other parts of this mishigas of a case, yeah, Mr. Jackson, I'm not going to be able to consider that because it's not in writing. It's not in writing. What? Yes, I did, Suze. Thank you for coming in with this. Anyone else notice Hank commenting that is familiar with the federal court system? Yeah, I've been around the block. I've done my time in federal court. I know how things work. I'm not new here. It's like, it's like when people go out with someone who went to Harvard, like we talk about this a lot, and they always mention Harvard in the first 5 minutes of conversation, or they're like name dropping, immediately. Like, oh, last week when I was hanging out with Bobby De Niro, or, last month when I was over at Angie and Brad's house, stuff like that. Like, excuse me while I bend over and pick up that name you just dropped. That's what he's doing here. Talk about trying to make himself feel important. Yeah. Hey, Hank, you lost both cases, says Suze. Thank you for your super chat. But yeah, that was just another patting himself on the back sort of thing. And we see that a lot with him. And people are, you guys write me emails. I don't always get a chance to respond, but I do appreciate them. So many of you comment on the videos afterwards, and you're just like, I never thought I would miss Lally, but. Right? Never thought I'd miss Lally, but I really miss Lally. As bad as Lally was, it was never like this level of I don't know, disrespect, blatant contempt for the defense attorneys and the defendant. I didn't get that vibe from Lally. It was just, not the brightest bulb, but, not really mean-spirited, right? No sort of, he didn't lack integrity, in my opinion. This is a whole new level of, I don't know, lack of integrity, decorum, basic civility to the other side. And I feel like when he's not right, and somebody said in comments the other day, if you don't have the law on your side, argue the facts. If you don't have the facts on your side, argue the law. If you have neither on your side, bang on the table. And that's what he was doing, he was banging on the podium. Like bang the facts, bang the law, or bang the table. He's banging the table, literally, with his binder. He was banging that podium. And I feel like he gets very angry when he knows that he's got nothing to argue. And it shows, right? So I think that's crazy. But here we are. Here we are. Still waiting. Like the talking heads, still waiting. Let's get to the chat for a second before we move on to the old order to order to not recuse herself. Izzy, thank you for thanking me. Appreciate you. Sally, Poltergeist, Bev picking her own four-person seems so unethical. Look, that is the way they do it apparently in Massachusetts. In New York, it is always whoever is in seat number one is the four-person. In other jurisdictions, they choose their own. The jury chooses their own four-person. I do not think that is necessarily one of the things that I would be angry about here, because I think the judge is allowed to do that. So let's stay focused. Focus. Brendan's Pixie Dust. Noel, I wonder, will AJ bring up Breenan's beautiful words from last week? I've turned over a lot less in this case. Yes, you have, Hank. Yes, you have. Hashtag where's the metadata? Well done. Irish Rover. Lally brought the snow at 12:10 a.m. Of course, everything happened at 12:10 a.m. in that trial. Everything. Thank you, Irish Rover, for your super chat. Kaylee Clark, Rustin Wire is here. Thanks for the 5. Love you. How does one become a member? Dummy over here and YouTube, stuff like that. I can't explain that to you. There's always a link in the video description that says become a member. You can click on that link. If all else fails, iPhones have a different system, so I'm sure one of the mods will be happy to help you figure it out if you have not been able to do that yet. VCaser, thanks for the 5. How about adding Solid as a Rock to our Spotify playlist? Maybe we will. The ground is hard as a rock. Yeah, well done. Breenan's body chalk. Marcy said, the story is more important than the truth. I swear to God, I watched him say it himself. Wow. I don't know where he said that, but interesting. B times C, thanks for the 10. Breenan is intimidated by all the skilled attorneys willing to come to Karen's defense. Hard to be a slime ball when she has all those sharp eyes on her side. Thank you for your opinion and for your 10. 13 Flags says, unfortunately, Bev doesn't care about the facts. Magnolia Gypsy says, Breenan is doing this one-man show vibe similar to Lally, but there are as many as 50 prosecutors in Norfolk County DA's office. Yeah, that's right, Magnolia Gypsy. Thank you for your 10. Appreciate you. Robin G says, funny that he has contempt for defense attorneys when he is one himself. I know. Remember when he first came on board, he kept referring to the prosecution as the defense. So he kind of slipped a couple of times and we picked up on that. And so he seems to have, he doesn't do that anymore, but the story is more important than the truth, says Breenan's Body Chalk again with another 5. Thank you so much, says Michael Marcy, apparently. Decline, thank you so much for your super sticker. For your super sticker. All right, let us take a look at that order. When she decided not to recuse herself. Talk amongst yourselves for a second. That is docket number 110, docket number 110. I'm going to put it up on the screen for 1 second, but I'm going to go off camera for 1 second because I just need to take care of one little thing. Fill up my iced coffee. I won't go far. Talk amongst yourselves for 1 second. But we're going to talk about all of the reasons why the judge did not see fit to recuse herself last time. In just a moment. I will be right back. Okay, I'm back. Did you miss me? All right. If you're just joining, we are waiting on the motion to dismiss to be docketed in the court and hopefully get a copy of it before we break today. We've gone over a few other motions that were filed this morning in filings. Thank you, Amanda, for buying me a matcha latte. I appreciate you so much. And so we've already been over a couple of filings. We're waiting to see if the impounded version or the redacted version of the motion to dismiss is going to be available today for us to look at for egregious governmental misconduct. And so I'm just going to put this up here because this has become an issue. For those of you messaging and asking about a Discord server, Team Brittany says this channel does not have one, nor do we give permission for one to be opened using my channel name. Sad to have to address this. I agree. I am never going to participate in Discord. I do not give anyone permission to use my name in any Discord type stuff. And there are people who are really like chattering about this, not only in my chat, but in other chats about starting a Discord for me. No, don't do it. Don't do it. Thank you, Team Brittany, for making that public. And it's bizarre. Like, I'm sorry. No, no, you can't. You can't use my name. Please don't do that. I'll say please the first time. Here, yeah, what's Discord? Melissa, don't even look into it. I don't even know, but I don't need any more Discord in my life, and it's nothing that I want anything to do with. Okay, so this is docket number 110. This is how old this thing is. Docket number 110. This was argued pre-trial, pre-first persecution of Karen Reed. This was based on the defense motion to recuse Judge Beverly Cannone. And this was decided, let me tell you when this was decided, 110, this was decided January 25th of 2023. Okay. So a little less than a year before the first trial ended, because the mistrial was declared July 1st. This is July 31st, 2023. And this goes back to a hearing. Let's see. I know that we covered the hearing together in the pre-trial playlist, but I don't think we ever went over the decision. And even if we did, we're going to go do it again. Okay, we're going to do it again because here it is. It's only 5 pages. Memorandum of Decision and Order on Defendant's Motion for Recusal and Disqualification of Justice Beverly Cannone. The defendant, Karen Reed, is charged with murder in the second degree in violation of General Law 265, Section 1, manslaughter while operating under the influence of alcohol, in violation of General Law Section 265, sub 13 and a half, and leaving the scene of personal injury and death in violation of General Law 90, Section 24(2)(a) and a half 2. On July 17th, 2023, the defendant filed the instant motion seeking my recusal and or disqualification. Okay, well, that's interesting because she says they filed their motion July 17th and she's already deciding it by July 31st. Actually, I think she decided it on the bench. The hearing, I think, was the 25th of July. There was a lot of stuff going on around this time. A lot of stuff. The motions were flying around to get Brian Albert's phone records and Jennifer McKay's phone records and Google searches. That actually went up to appeal to the SJC. We covered that in the pretrial playlist. So she had already decided this by the time of the hearing, which was like a week later. That's a pretty hefty motion, right? That should take a little bit longer. There were discovery motions that she held onto for 60, 70 days. Defense motions for basic discovery. And she's deciding whether or not to recuse herself within a week. I don't know. And then listen to the shade, or see if you can just pick up the shade that she's throwing on the defense here, because it's in here. The motion is 29 pages in length and supported by the affidavit of Alan Jackson, admitted temporarily to practice in Massachusetts pro hoc vice, and in what has become standard for motions in this case, but not typical of the practice of Massachusetts lawyers. See that? Like putting in a court order your disdain for out-of-state attorneys that are pro hoc vice is a little bit insane to me. Let your bias show in a court order. Like, that's wild. It's not how we do things here in Massachusetts, Mr. Jackson. We don't file long motions with actual exhibits to them. We don't do that here. It's not the way we do it. To repeat that, she says, and in what has become standard for motions in this case, but not typical of the practice of Massachusetts lawyers, incorporates exhibits consisting of photos of the deceased John O'Keefe, a paragraph from a Celebrite report, an unauthorized, unofficial copy of the deed to a home owned by this judge that also includes the address of my primary home and a quitclaim deed of a property sold to Sean C. and Marnie I. McCabe in 2007. The docket of this case, a 52-page transcript of a prior Massachusetts Rule of Criminal Procedure 17 motion hearing, email threads between counsel and the Norfolk Superior Court Clerk's Office, an email chain of counsel in this case, a 53-page transcript of a hearing before the court on May 24th of 2023, and comments of unnamed people apparently posted on the internet. Okay, I'm going to break from this to say, what part of this is not done in Massachusetts? Exhibits? Attaching things that you're referring to so that the judge doesn't have to do the work and dig up a transcript of a prior hearing? Trying to actually show receipts and give the judge evidence of why you're arguing for what you're arguing for and why this stuff is relevant and material, and here's a deed to your house and here's a deed to a house owned by the McCabes, and maybe you know each other. Maybe it's the appearance of impropriety here because you share the same beach access. And because, all right, it's going to go on to explain this, so I don't have to do it. The defendant also filed an affidavit of Aidan Carney in support of her motion. That also includes what appears to be an exchange Carney had with Sean McCabe, period. Sean McCabe is, I believe, the brother of Matt McCabe, right? After a hearing on July 25th, 2023, and review of written pleadings and attachments submitted, and consideration of the Supreme Judicial Court Rule 3.09, Canon 2, Rule 2.11, and the case law, the defendant's motion is hereby denied. Discussion. A judge shall disqualify himself or herself in a proceeding in which the judge cannot be impartial or the judge's impartiality might be reasonably questioned. Might be. That is the SJC Rule 3.09. If you'd like to look it up, Canon 2, Rule 2.11a. Recusal generally is left to the discretion of the trial judge, which is also wild to me because we looked at another motion in another case, refresh my recollection about which case it is, where they made a motion to recuse the judge that was sitting in this case. Was it Sarah Boone? I don't recall, but it was heard by, it was one of the defendants that had been representing themselves at the time. Was it Robert Tellis? Maybe it was Robert Tellis, Boss Baby trial in Vegas. Made a motion for that judge to recuse himself or herself, and that motion was heard by a different judge. Maybe that was Nevada. It's not the way they do things in Massachusetts. Recusal is generally left to the discretion of the trial judge. When faced with a question of her capacity to rule fairly, the judge must consult first her own emotions and conscience. Citing case law. If the judge concludes that she is free from disabling prejudice, she must next attempt an objective appraisal of whether her impartiality might reasonably be questioned. Applying this objective and subjective standard, I have concluded that my recusal and disqualification is not required. Yep, she can't, right, Bethany says what you're all thinking, and she can't even control her emotions. A lot of people are saying that the other day. She wasn't able. No, it wasn't the only motion. It wasn't the only reason for the motion to recuse, but we're getting into it. There are 4 reasons, and here they come. Thanks, Karen, for pointing that out. The defendant has raised 4 bases for recusal. All 4 are without merit. First, the defendant asserts that Sean McCabe, a family member of a witness in this case, made extrajudicial statements insinuating a personal relationship with me and the ability to influence me. I do not know Sean McCabe or any member of his family or any other named witness in this case. Any suggestion that I have a relationship or connection with any witness or family member of any witness would affect my impartiality is unfounded and purely conjecture. I also do not find that my impartiality might reasonably be questioned by a fully informed, disinterested observer. And there she is citing SJC Rule 3.09, Canon 2, Rule 2.11. In the comments, it says, a fair reading, oh, well, no, she goes on to say, oh, that's footnote 1. Wait, is there a footnote here? Indeed, Carney's response to Sean McCabe indicates that he also did not believe that McCabe knew me at all. I don't have the exact screenshot in front of me, but apparently Sean McCabe reached out to Aidan Carney via, I think, Facebook Messenger. I'm not sure. Don't quote me on the exact mode of communication, but I don't know if they had a phone conversation first, but then there's screenshots of messages between them. And Aidan says, wait, are you saying that you have a line to Judge Cannone? And Sean McCabe responds, allegedly, that it's really him. Oh, you mean Auntie Bev? That's where the Auntie Bev came from. Oh, you mean Auntie Bev? Whose seaside cottage do you think we're going to bury your corpse under? And that was part of the motion. And then his response was something like, I don't remember what his response was, but maybe that's what she means by his response. Oh, you really have a line to the judge? A fair reading of the exchange between Carney and Sean McCabe does not credibly suggest any relationship between Sean McCabe and myself. Oh, and that's where the footnote 1 is. We just read it. Sean McCabe's use of my name or information publicly available about me does not conjure up an appearance of partiality on my part. Conjure up. It's interesting how witchcraft comes into this, kinda, sorta, when this is like a witch trial. Nor is it possible to manufacture an appearance of partiality by utilizing a blogger, wait for this, ready? Listen up, who is not subject to the same high ethical standards of attorneys and members of the press, to spread rumors on the internet and pass them off as the truth. I'm sorry, but members of the press are held to higher ethical standards? Wait, do you mean the members of the press that reported that investigators told them on January 29th of 2022 that there was ring video footage of the incident of Karen Reed hitting John O'Keefe with her car? You mean those members of the press? Because that's never been redacted as far as I know, or retracted, I should say, by the media. It was picked up by local stations and immediately was in the Daily Mail within seconds because, internet. You're talking about those high ethical standards? And also, if you're not calling him a member of the press, why does he have a media pass to get into your courtroom? Yeah. Right? So you can't believe what Aidan Carney says because he's a, quote, blogger, and he's not subject to the same high ethical standards as attorneys and members of the press. Because if an attorney said it, I would believe it. Like when Hank Brennan got up and told me those things in court the other day, even though he didn't put them in writing, I believed him because he has a higher ethical standards and he would never lie to me. Well, guess what? He did. He did. And you're going to hear about it tomorrow. So there's that. See In Re United States, which is a First Circuit case from 1998. And she quotes, a party cannot cast sinister aspersions, fail to provide a factual basis for those aspersions, and then claim that the judge must disqualify herself because the aspersions ex proprio vigere create a cloud on her impartiality. If such were grounds for recusal, it would permit those with dubious motives to manipulate what cases judges can and cannot hear. See Edinburgh, 1986 case. And she quotes, the rules governing the recusal of a judge are not intended to provide litigants with a means of obtaining a judge of their choice. Indeed, a judge may very well have an obligation to resist a challenge to her impartiality, which is tenuous, baseless, or frivolous. And then she cites In Re Bulger, which, yes, is the Whitey Bulger case, First Circuit case from 2013, and cites it for the proposition that says, noting that application of the analogous recusal standard under federal law is necessary, quote, to prevent parties from too easily obtaining the disqualification of a judge, thereby potentially manipulating the system for strategic reasons. Except, I believe, I don't know if I've read every single In Re Bulger case, but the one that I read, the judge actually did recuse himself because appearance of impropriety. Appearance. Joe says all this press nonsense is in all of the cases. Legacy press is dead. The press is the people more and more now, and thank God for that, right? How many of you no longer watch mainstream media? Wave to me in the chat, or you know what? Let's put a 1 in the chat if you no longer watch mainstream media and get your news from YouTube and other places. I know there's a lot of you because you're always saying it in the comments. A lot of you. Somebody's like with 4 1s, 5. Yeah, a lot of you. Don't watch mainstream media anymore because you can't trust it. People can't dissect and talk about things and go over court documents for hours on mainstream media. They just don't have the time to do it. I see you. I see you, ones. I see you. Moving on. The defendant's second and third arguments pertain to discovery motions filed by the defendant. The defendant asserts that I have refused to rule on defense motions in a timely manner and have denied the defendant an opportunity to be heard on a critical discovery motion under Massachusetts Rule 17. I do not agree with defendant's assertions. I have addressed every written and or oral motion consistent with superior court rules and standards. With respect to the defendant's specific argument regarding her Rule 17 motion for cell phone records, I carefully considered the defendant's arguments concerning that motion, and my oral and written ruling followed the procedure and standard set forth in the rule and controlling precedent. See Commonwealth v. Dwyer. The fact that the complaint of motion was not decided in the defendant's favor does not mean that I am partial to the Commonwealth or that a fully informed, disinterested observer would question my impartiality. Footnote 2. Thank you, Team Brittany. I see you. Footnote 2 says, I note that I ruled in the defendant's favor in a separate Rule 17a motion, where unlike the motion for the cell phone records, the defendant met all the requirements for the discovery. See docket number 79. Look, every now and then I throw you guys a bone. Every now and then I do. Look at docket number 79. I did. I ruled in your favor. Yeah, but it took like 60 or 70 days or something, such as like that. And the cell phone motion that she denied went up on appeal. It went up on appeal, and it was overturned on appeal. Hang on, I just got to take this call. Okay, I'm back. That was overturned on appeal. And I just want to also point out, had the Commonwealth turned over that video from the Sallyport exterior camera that they just turned over within the past 2 weeks or something, or maybe they turned it over in October, I don't recall, because there's been a drab droppings of assorted video from January 29th that has been randomly dropped upon the defense after the trial, but before the second trial, wherein Brian Higgins was on the phone at 1:30 something in the morning when he's exiting the Canton Police Department. If that video had been turned over, do you think there would have been a good faith basis to obtain Brian Higgins' phones? Yes, there would have been. And do you remember there had been a protective order issued to preserve those phones? And maybe, just maybe, Brian Albert and Brian Higgins were tipped off, because even Higgins said on the stand when he was cross-examined about it, oh, the preservation order was denied. It was denied. And that's the day after. The day after is when I went and, destroyed my cell phone on the military base and cracked my SIM card in half and got a whole new number, and, all that stuff was lost. But I did go to the FBI kiosk, and my friend Matt Kelch helped me download a whole bunch of text messages between myself and Karen Reed, which I then brought in. I printed them up and I brought them in, for my interview with the whoever interviewed me in this case. So I turned that over willingly, but they totally wouldn't have been able to get Higgins' phone records if that had been turned over in a timely fashion, as required under the automatic disclosure rules. And yet, they just didn't. They just didn't. And wasn't it the exact same day that Brian Higgins destroyed his cell phone and got a whole new number, that Brian Albert also got rid of his phone, and maybe even he got a whole new number? Remind me, refresh my recollection. Pointing out the obvious. Uncle Brian A. How creepy is that? That he's apparently in someone's phone as Uncle Brian A. It was all the same day. They both got rid of their phones on the same day, which is like the day before a preservation order was it ever issued? Because it had been denied. Then it was issued. Yeah, it's insane. But they didn't get the formal paperwork for it. But yeah, right, all that. But they knew it was coming. It's like a whole thing. It's like a whole thing. Right again. Tripping Gauntlet says right again, Melanie. I don't know. I've got a brain for details, and I remember these things. All right, moving on. She says, I recognize that it is the right of every citizen to be tried by a judge. Oh, wait. I got to go back. That was footnote 2. So we have to go back to where footnote 2 was. Which is where? Oh, here it is. The mere fact that a party suffers adverse rulings during litigation does not establish lack of judicial impartiality. Finally, the defendant argues that I have or intend to deviate from superior court procedure by ruling on the Commonwealth's motion to prohibit extrajudicial statements. That was a gag order. The Commonwealth moved for a gag order on defense counsel. It was denied. And that is when Michael Marcy went into his conference room and recorded that hostage statement that he then gave out to the media or put on YouTube or published somewhere. wasn't a press conference. It was just Michael Marcy's hostage statement after the gag order was denied, right? My handling of that motion in this case is consistent with my duty as regional administrative justice and with Massachusetts Superior Court practice. It is not grounds for my recusal or disqualification. I'm going to point out again, in case you weren't here in the beginning of the stream when we talked about this, that the fact that Justice Cannone was not only the trial judge in this case, but also the regional administrative justice. Judicial immunity exists for judges in the course of their regular judicial duties and rulings and handling of things like trials, in court proceedings. Does not extend to, in my opinion, or according to the knowledge that I currently have, administrative duties, such as maybe assigning Trooper Fanning to be in charge of the jury in this case, if that is true. And so perhaps the judicial immunity that she might be afforded as a luxury in these rulings and decisions and gatekeeping function would not protect her with regard to administrative decisions in that dual role that she has as being the regional administrative justice and a trial court judge. Two different positions, two different duties and responsibilities, and I think two different levels of protection for a judge. Okay? I'm just saying. Snark Tank is on fire. Snark Tank's on fire. He's a decorated dude. Cat's meow, he's a decorated dude. So there's that. She says it is not grounds for my recusal or disqualification. I recognize that it is the right of every citizen to be tried by a judge, quote, as free, impartial, and independent of the lot of humanity will admit. And that is according to the Massachusetts Declaration of Rights, Article 29. See Beauregard v. Daly, 1936 case from Massachusetts, digging deep for the B-side, deep cut. The deep cut. As a former criminal defense lawyer, she puts that right out there. As a former criminal defense lawyer, I spent my entire professional career representing the defendants accused of serious crimes in the Superior and District Courts of Massachusetts. I understand full well how critical it is that the judges are impartial and honor their oaths and ethical obligations because defendants deserve to have their cases heard by fair and impartial judges. She's putting all of that right there in her order. She was a defense attorney. She knows what it's like. She knows how it is. And she knows how important it is full well. She understands full well how critical it is. Her entire professional career. While defense counsel argued that a commitment to justice and fairness requires that I recuse myself, it is because of my commitment to justice and fairness that I will not. Why is that? Because no other judge could do it as well as you can? Because you believe that you are the best judge to decide this case? When so many things here are outside of the ordinary and all of the things that she just set forth in there about Sean McCabe, and then she didn't even address the Venmo transaction that they showed in court between Julie Nagel and Ryan Nagel about Frank and Beverly. And Beautiful Distraction says, that's funny AF. Funny as duck. There's an order posted. Let's see if we have it yet. Docket 518. It may be docketed, but not. There may not be a copy of it yet. Hang on. It's not in my inbox. If you have a copy of it, you can email it to me. Fanbase@mlittlelaw.com. Fanbase@mlittlelaw.com. Yep, I see it. 518 order ruling on motions heard on February 18th. See attached rulings. It doesn't mean it's docketed. It's docketed, but I don't see it yet. Okay. Waiting. If it comes up, thanks, Vanessa, for being on it. Allowing a motion for recusal based on unsubstantiated rumors, the use of a judge's name, or dissatisfaction with a judge's rulings would subvert the recusal standard and allow for the manipulation of justice and fairness. I've examined my own emotions and conscience and determined that I have the capacity to make fair rulings in this case. I have also conducted an objective appraisal of whether my impartiality might reasonably be questioned based upon the matters raised by the defendant, and have determined that it may not, that her impartiality may not be questioned reasonably. Accordingly, there are no grounds for my recusal. Order, for the reasons stated above, it is hereby ordered that the defendant's motion for recusal and disqualification is denied. Denied. And that is dated July 25th of 2023. Those are her reasons. Just giving you a million reasons and a million reasons and a million reasons of why she won't recuse herself. XOXO, Justice Beverly, with an LY, not an LEY, Cannone, Justice of the Supreme Court. Therefore, she doesn't know those Nagels either. She doesn't know the Nagels. She doesn't know the McCabe's. And so there's that. So whoever just emailed me, docket number 516. We already went over that at the beginning of the stream. So if you were not here for that, thank you so very much for emailing it to me. But we have already been over that today. That is the defendant Karen Reed's motion to impound portions of the defendant's motion to dismiss for extraordinary governmental misconduct. We went over that at the beginning of the stream. But thank you so very much for your collaborative nature. I appreciate you all so very much. So what we're waiting for now is docket number 518 for the rulings on the motions heard on February 18th, but we'll go to the chat right now until we are able to obtain a copy of that. I'm going to put my email up here in case anybody has a copy of it, and you can feel free to email it to me if you get it. Back to the chat. Thank you. Bearden's Body Talk said LTL aired an interview of him where he said it, going back to Marcy's comment. Thank you very much for your super chat, Mrs. Mark. Thanks for becoming a member. Pam McKinnon, thank you so much for your super sticker. Should she be making rulings right now? Look at that. Good timing, because there are some rulings. We just can't get them yet. Waiting. We're here for it. Pam McKinnon, Sparky doesn't trust the Tink team, should we? For your super chat. Al Dente from Canada. We have the dream team for the Commonwealth has the Rugrat team. Angelica, Chucky, and Dill Pickles. She's saying the judge is Angelica, Chucky is Brennan, and Dill Pickles is Lally. That's hilarious. You're very funny. Those of you who know, Rugrats. That Angelica, she was so mean. Curious Liz, thanks for the 5. Do you think the motions to recuse should be heard by an independent judge? I do. It's done that way in other jurisdictions. Like when it wasn't heard the case at all, seems like it would help to me. I agree. I'm with you on that one. I am with you on that one. K-Wag says, I think we had hope with Hank Brennan that the trial would finally be fair. He's been disappointing and shown he's dirty, in my opinion. I have zero respect for him. Yeah, did any of you watch? Some of you guys pointed it out to me, and some of you were kind enough to send me the timestamp on where to look for this, but I think it was on Law and Lumber's channel. Runkle was on one day over the weekend, maybe, and they were talking about it. And both of them said, or maybe it was Rob who said, I was really giving, Brennan a fair shake, and I really wanted to give him like the benefit of the doubt. And now I just think I'm not going to quote him, but he was not happy and has changed his opinion on Brennan. And I think that there are also other people out there on the interwebs who feel the same way. Nina says, why couldn't Bev, Nina, are you from Czechoslovakia? Why couldn't Bev just ask AJ if he wants to respond or needs more time? She didn't even want to give him a chance. Happy Monday from the Swiss Alps. Yeah, there you are in the Swiss Alps. Switzerland. I'm like Switzerland too. I try and be like Switzerland. That's why my mods are super strict here, because there are other places for drama. This is not one of them. And if you don't like it, you don't need to complain about it on Twitter. Agreed. He should have given him the opportunity to correct the record at least, and then say, I will give you a more fully fleshed response next week. But I would just want to point out here, Your Honor, that we turned all the stuff over to him. And he probably could have clarified a lot of that right then and said, this invoice is for the next trial, like whatever the explanation is going to be. And I don't know what the explanation is going to be. But I think a lie unchecked becomes the truth if it's left to hang out there, for a week. So agreed, Nina, I agree. Sage, according to the anti-free Karen readers, warrants were served and evidence collected at ARCA in Philly on 2/22. Yeah, I'm sure that's true. Also, I'm not sure that's true. I think that's hilarious. A lot of people just post things that are tongue in cheek. They don't really expect people to take them seriously, but a lie unchecked becomes the truth, Sage. So also indictments in Dr. Wolf and the Fed investigation was over in February. Desperate like Brennan. Yeah, people are doxing Dr. Wolf's family online, and it's crazy. Sage, thank you for your super chat. Not on board with any of that stuff. Somebody said ARCA's not in Philly. I don't know. Irish Rover, did the FBI kiosk invert the video for Higgins? No, but that's how he got his text messages and printed them up. But who knows at this point? I mean, nothing strains credulity at this point. Nothing strains credulity. Oh, thanks, Emma, for the matcha latte. And again, happy birthday to you. Antiba's mugshot comes in with a hot 20 and says, Tuesday will be crazy. I can't wait to see Spanky sit with his tail between his legs. Also, I think I heard Ms. McLaughlin was the one that gave Spanky the material. Ms. McLaughlin was the one that gave him the material? No, I think she's the one who handed it up to the judge. She said, here, judge, here's the exchange, the discovery exchange. Because the judge said, I want a copy of that before you leave. And she handed it up. I hope they all look good in orange. Love you, Mel. Thank you. Thank you, Andy-Baz Mugshot, for your very kind and generous super chat. Moon Goddess gifted 5 memberships. Thank you. Thank you so much. Moon Goddess is here. Moon Goddess went to the trial of Penny McGee. She was boots on the ground. She was there. And that was awesome. That was a bench trial by Judge Cannone, and she acquitted Penny McGee. For those of you who don't know, go back and watch it. I think we only have 4 videos on it. It was a very short bench trial in front of Judge Cannone within the past, when was it, last month? Penny McGee was on trial for manslaughter, facing 20 years in prison because her ex-husband, with whom she had an argument, she may or may not have shoved him during the argument, he dropped dead of a heart attack, and she was charged with manslaughter because in the medical examiner's opinion, because there were 2 people in the room, it had to have been caused by one of them. Therefore, homicide. Interestingly enough, in the autopsy room, while she was conducting the autopsy of Andrew Savitz, the ex-husband of Penny McGee, Trooper Kikowski was in the room when she did the autopsy. It was Rebecca Dietrich, the ME. It was not Irene Scortibello. Trooper Kikowski, do you know who that is? Well, his first name is Jeff. I'll give you one clue. Second clue is when DeChico sent that group text message to Proctor and Buchanan and whoever else he sent it to about the Karen Reed case and said, rookie move. You should have had me and Jeff do it, meaning talk to the medical examiner to get her to change the manner of death from undetermined to homicide. Jeff is Kikowski. Interesting? I think so. Anyway, Penny McGee was acquitted by Judge Cannone very quickly from the bench on all charges. That was wild. Just another example of, Norfolk County persecuting cases that probably shouldn't have been brought in the first place. Tracy says, are they holding on to this case so tightly because their corruption has been established, in my opinion? In the Birchmore cases, I don't know. In the Birchmore case, I don't know. Wasn't Trooper the lead? Trooper Fanning, or Lieutenant Fanning, whatever the hell he's called now, wasn't Fanning the lead in the Birchmore case? Isn't it speculated that or theorized that the feds stumbled onto Karen Reed or got involved in the Karen Reed case because of the Birchmore case? Could be. Tracy, everything could be connected. I wouldn't be surprised at all. Thank you for your generous super chat. Dr. Russell is the GOAT, says from Norway, TikTok psychic motion to recuse another judge. That was another one. I didn't follow that case, but thank you so much. Julie says, docket 5-4 updated to allowed on 221. Does that mean she imposed sanctions on defense? Oh, hold on. Docket number 514. Commonwealth's motion to impound exhibits. No, that's the Commonwealth's motion to impound exhibits in support of Commonwealth's motion to impose sanctions. No, that's just their motion to impound exhibits. So apparently she allowed that on Friday. It's just showing up in the docket today. So the exhibits can be impounded. It doesn't, no, the sanctions motion has not been heard yet. She can't rule on that yet. The defense has not had the opportunity to argue that in court. That was the audio recording, yeah. Correct. No, what we are waiting for is docket number 518, which is the order, the rulings on motions heard on February 18th. We are waiting for that. And I don't have it yet. And also we're waiting for the motion to dismiss, whether it's the redacted copy or thank you so much, Julie, for your super chat. Whether it's a redacted copy or whether she's going to impound the whole thing. But in my opinion, she can't impound the whole thing because that motion that we just looked at for sanctions has not been heard yet. And so she can't rule on it, right? In my opinion. Your thoughts on why the emails had no dates? My thoughts are that he lied and that the email does have the date and it was cut off on his photocopy, or that he didn't know where to look for it, or I don't know. So I have no idea. I can't really speculate, Nina, but I have a feeling that when we find out tomorrow, that maybe, just maybe, he may not have been telling the truth, the whole truth, and nothing but the truth. So help him, whatever gods he believes in. Hannah, thank you for your super chat. Hanky's going to regret opening this can of worms. It shows he's desperate with the hard ground guy coming in to prove John's head injuries from the UK. Thank you so much, Hannah, for your super chat. Agreed. They really, 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 really do not want the crash daddies to testify in this case. They really, 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 really don't. Because that is why he's bringing up all of these ethical violations. Like, and as a sanction, Your Honor, you should just exclude them from testifying. There's no good faith basis to do that. There's no legal reasoning to do that, but they really don't want them to testify. Moon Goddess thanks the 5 2 different judges, which is why I went. I wanted to see how she was in her normal element, right? She was there for Penny McGee. She saw Dr. Cannone, Judge Cannone in the flesh, and different demeanor, right? Different disposition, different demeanor. And in that courtroom, exactly, someone's pointing out, during the Penny McGee trial, the places in which the defendant's family and the victim's family sat were flipped. So you know how Paul O'Keefe is always looking at Karen Reed? In the Penny McGee trial, the family of the victim was sitting behind the defendant, where Karen Reed's family sits, and the victim's family, and Penny's supporters and family were to her left, where Paul O'Keefe and Peggy O'Keefe sit. So it was different. Can the defense in Karen Reed's case make a motion to flip them? Maybe. Is it different because that was a bench trial? I don't know. But, the judge is the gatekeeper. She has discretion. She could flip it. Sweet Caroline said, Lally, cut the dates off. Shh. Shh. Look the other way. Don't tell anybody. Thank you, Sweet Caroline, for your super chat and for that great Neil Diamond song that everyone loves so much. Ba, ba, ba. Times never feel so good. So good, so good, so good. What motions were heard on February 18? Well, all the motions that we watched the hearing of. We watched the motion to compel discovery, which is turn over all of the Sally Port videos, chain of custody logs and evidence logs and things like that. Tell us who touched every Sally Port video and the chain of custody with those videos. Thank you, Sweet Caroline, for your very generous $20 super chat. And the other assorted motions that we heard, such as, guys, point them out to me. My brain is already getting to be mush because some of them have already been granted. For example, the one that was granted was the one where, the one that was denied is the one where the defense doesn't want to have to turn over their impeachment evidence. She denied that. That appeared in the docket mysteriously. So they're going to have to turn over their impeachment evidence, which is wild to me because that's not the way we do it in New York and in many other jurisdictions. Just like take away all the smoking guns so the witnesses can be prepped on them. Seems insane. And it is. It is insane. Oh, to get the copies, right, of the Birchmore unredacted police reports, to get the copy of Proctor's internal affairs report, they didn't hear the motion on to exclude James Crosby, the forensically sound copy of, to get all the metadata. And so we're waiting for that. It's raining cupcakes. It is raining cupcakes. Oh, Sarah and Chaganhar gifted 10 memberships. That's what you meant. Thank you so much. I appreciate you so much. Not only is Sarah in Schwackenhara an amazing moderator for the channel, but she's also a very generous and super cool chick who has gifted 10 memberships. 10 memberships. Let's just take a look here and see if we can find that in another location. All right, we already went over the motion to exclude the meteorologist, Weatherman. All right, back to the chat. Thank you, Sarah. Jeannie Lynn, thank you for your super chat, says, do you think Steve Scanlon will ever come forward and tell the truth about what he heard? I don't know. And I wonder why we can't subpoena him. I don't know. Because you don't typically you wouldn't subpoena a witness when you don't know what they're going to say. That's risky, right? I mean, you could subpoena him to come in and testify, but if you don't know what he's going to say, that could be a smoking gun or it could be a loose cannon. You don't know. You don't know. For those of you who don't know who Steve Scanlon is, Steve Scanlon is allegedly a guy who called David Yannetti like the day after, within a few days of John O'Keefe being murdered, and claimed that he knew what happened and that John O'Keefe was beat up in the house and left to die in the cold. Thanks, Jeannie Lynn, for your super chat. And I don't know. My crystal ball is broken. I don't know what that guy's going to do, but he could be afraid. He could be afraid for, his life. He could have been threatened. I mean, you see what people do on the cesspool of Twitter and in other locations to try and just shut people up like me from talking about this case. You see what goes on out there. You think maybe this guy could be in fear for his family? You see what they're doing to Dr. Wolf's family out there, what they've done to Dr. Marie Russell, what they've done to Richard Green. These are just expert witnesses that are coming in to testify for Karen Reed. Like, it's insane. It's insane. I have no doubt that he's afraid. You know who's afraid? Gretchen Voss. She's put it in writing. She's had death threats. Please don't release my notes because they're already coming for me and my family. Like, I'm gravely concerned for my safety. And based on that, the judge denied that her notes, the motion to turn over her notes to the Commonwealth of her interviews with Karen Reed, her off-the-record notes. Because not only is she afraid for her family's safety, but who's going to ever speak to her as a journalist when everything is off the record is never really off the record in Massachusetts, but it's Massachusetts. There is no journalistic shield or privilege. It is one of a handful of states that does not recognize journalistic privilege or shield. KLM, thanks for your super chat. I thought McLaughlin set Brennan up at first, but now I don't know. He did say she gave him the emails in the beginning of him talking, but I could be wrong. Yeah, I don't know. Without going back and watching that hearing again, I don't know, but I did notice something in that hearing the other day when I started watching like the clean feed of it, like the law and crime feed. Let me just see something here. Hold on. Hold please. Talk amongst yourselves for a second. Oh, I can't. You know, at the end of that hearing, all right, well, let's take a look at this. At the end of the hearing, when it ends and Brennan comes down after his little monologue there, there's an exchange between Alessi and Brennan. Now that I have my headphones on, I might be able to hear what Alessi says to him. Watch this. It looks like he's saying to him, "What do you do? Do you have any lip readers in the chat?" He's like, "What are you doing? What did you do?" And that looks like what he's saying. And then look, Brennan like pats him on the shoulder, like, "Hey, don't worry about it, dude." Sound is off, so I can't hear what they're saying. But I mean, this is wild. Hang on, let's take it back a little bit further. They're like, "What is going on?" They start discussing scheduling.
Okay. All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
Oh yeah, let's watch it in slow motion. Good idea, Kimberly. Hold on. Because not only can you play back things in fast speed, but you can go back to let's go back to quarter speed and see what happens next. Watch. He said, "Why did you do that?" All rise. It sounds like a ghost. Oh, it's so ominous sounding, isn't it? Did you see that motion that Paul O'Keefe just made on with his wrist like this? He did this. I don't know if that was another hand signal that he talked about in those messages. Let's not. He's like, "Yeah, no worries, bud." It's hard when he has glasses on because the reflection is in there. He's like, "What did you just do?" What say you? Why'd you do that? It's like the sound of the portal to hell, says Trish. Here's something else that I noticed. If we go all the way back to the beginning. Wait. Let me just put it on normal speed for a second.
Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Adam Lyle for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
Yeah, the hand signals. Watch Paul O'Keefe in the background. Hold on. When they show Karen, there's a point here where they're focusing on Karen, and it's during the break. Hold on. And I noticed this when I went to replay it like the other day. All right, focusing on Karen. Watch Paul O'Keefe's hands. Hold on, wait. Let me just pause this for a second. I'm pretty sure this is where I saw it. Hang on. There he goes. He goes to touch his chin, and then it happens again. There was another. Okay, wait. the ear, the chin, right there, he does this. And that's exactly what those text messages said to that woman, allegedly, that he was allegedly speaking to. Says, I'll touch my chin with my pointer finger when I'm thinking of you. And that's all I'm going to say on that. Wild. Don't go off on any glazed talk. And that's not the only time it happens. It happens several times during the course of that hearing, or more than once anyway. More than once, I'll say that. All right, well, I don't know if we're going to be able to get a copy of 518 right now, but if we do, we'll go over it. I don't know if the motion is going to not be released right now, or if it's going to be released later, or if it's never going to be released. But we've been here for almost 3 hours. Thoughts, questions, comments, concerns before we wrap this stream, and make sure you have all notifications set, because if I get that motion to dismiss, we are coming right back on. We're coming right back on with it. You may not get any time to, get camera ready or anything, or get your coffee. Lisa Marie in Tennessee, thanks for the 20. It's sad that the judge worked hard to get where she is today, and that this case that she just had to take on with her obvious bias and questionable rulings make her look like a fool. Thank you, Lisa Marie, for your opinions, thoughts, and for your super chat. Judge Cannone, Hulda, Iceland, Spain. Thanks for your super chat. It says, I want to see Judge Cannone's phone records and emails. I think a lot of people do. Well, if they're contained in any of Morrissey's emails or phone records, they're coming out. I don't know. Why is that not witness intimidation? Great point. You know why? Because there's selective prosecution of the laws, especially as they regard to witness intimidation in Massachusetts. It's selective prosecution. Thanks, Tracy. Greg says they hired a mob law lawyer for a reason. Nikki, thanks for new rulings decision on the docket. Yeah, I know. I mean, I know it's on the docket. I don't know if it's been scanned in yet. It's docket number 518. That's why my email is up, in case anybody has a copy and they want to email it to me, or they see it posted somewhere and they want to email me the link or a screenshot. We can go over it. But sometimes they put them on the docket, but they don't scan them in yet. And so we're waiting. Yes, thank you. Thank you, K. Willis Realtor. That's exactly what I'm talking about. Rulings on motions heard on February 18th. Yeah, but it's not. I don't have it yet. Thank you. Thank you. If you have it, email it to me. Thanks, K. Willis, for all your real estate needs. I mean, I can wait a few minutes and see if it shows up. Thoughts, questions, comments, concerns. Who's changing their screen name to Paul's pointer finger? I wasn't born with thorns. Well, understand too that was a motion that was heard in the summer of 2023. That motion to recuse, and the order that we just went over was from all the way back then. So there's that. She says, as she won't recuse, I'll now call her Judge Cantaloupe. Very good, Judge Cantaloupe. Very, very, very good. Well done. Well done to you. Well done to you. Mass Courts, somebody just sent me an email asking for the website. It's Mass Courts, masscourts.org. That's how you can access Massachusetts cases. You can't always access the documents. What are sanctions? Sanctions are like a punishment. Sanctions are a punishment. I don't know who put that in there. It says Chadwick Canuck. So it could be, there's different kinds of sanctions. It could be monetary, could be, excluding evidence or precluding an expert. So there are different types of sanctions for different types of things that are allegedly discovery violations or ethical violations, or such as things like that. It depends. It just means like punishment. Mama says Brennan gives 2 dates, March 22nd, 2024. And that, right. And he said, but March 22nd, 2024 is when I think Alan Jackson sent him an email saying, we want to retain you to testify at trial. And then that is quickly shut down when he receives an email from Dr. Wolf saying, no, we can't. We have to halt because the federal government says we're still under contract, so you cannot retain us. There's something about talk of an engagement letter. And then he says Saturday, June 22nd for the correspondence between Arca and Jackson, which was after, I believe, the voir dire had happened, because Dr. Wolf says in that email, like, your voir dire questions were great. Ask me if you want to clear anything up, or you want me to clear up how many times I've testified and been deposed. And then he proceeded to say no dates on February 18th at 1:10. Yeah. So yeah, exactly. It's all going to be cleared up tomorrow. And there's so many, I think, misstatements and misrepresentations to the court that if it's pointed out that Brennan did that, that Brennan did that in open court, is she going to sanction Brennan for doing that in open court? So that's kind of weird. I don't know what happened with Dr. Wolf's family other than people were posting, I think, pictures of them. I don't know. Those of you who are like out there on Twitter may know. I don't know, but I've just been told that there's something went on with some trolls for the other side posting, I don't know, the wife's Facebook pictures of his children, things like that, to the point where it's been reported that ARCA took down their Twitter. And they think that this is like a victory lap. They're doing a victory lap. Like, we kicked him off of Twitter. We got him to. They think they did that to me too. I was never really on Twitter anyway. I had an old account that I never used. And all of a sudden, the trolls were out there tagging me in things, saying all kinds of nonsense about me that I'm just like, I don't need to be on Twitter. It's just like, who needs more discord in their life? Not me, but they think they scared me off of Twitter when I never really used Twitter in the first place. So, okay, you scared me. Like, really? No, you didn't scare me off of Twitter. It's not a place I want to spend my time. It's a time suck. It's full of lies and misrepresentation. And there's a world out there where people can hide behind fake screen names and say whatever they want about anybody, and there's no ramifications for their behavior, apparently. So there's that. Yeah, you're not scaring me away from talking about this case. You could try. But it is a hellhole. I agree. They didn't scare me off of Twitter just to clear up those rumors. But, they're doing the same thing to Nan now, Nan Gallagher, who's a new attorney that came out and is starting to appear on a lot of YouTubers' channels to talk about the case. And she's very outspoken, and they've been doing the same stuff to her. It's like the target changes every week. So who are they on this week? I don't know. But apparently Dr. Wolf's family. Yeah, so there's that. Yeah, if the cops wanted to, they could trace the people intimidating defense witnesses. Yeah. I was able to do it. I know exactly who it was that posted stuff about me. It's not hard to figure out who these people are. They think that, hiding behind a fake screen name is going to protect them. It's not. It's still actionable if you defame someone publicly and dox them, threaten their family. Like, people can find out who you are. It's not hard. But Colin points out the obvious. If the cops wanted to, they could trace the people intimidating defense witnesses. They could. But again, they don't care to prosecute people that they don't want to prosecute for whatever reason. It's only the people who think Karen Read is innocent, apparently. Right? Oh, Olivia's here. Hi, Olivia. I'm just waiting to see if we have a copy of docket number 518. I don't know if you've seen it yet, Olivia, but there's been an order ruling on motions heard on February 18th. It's been put into the docket, but I don't know that it's been scanned into the docket yet. So I don't know. And also the motion to dismiss. There was a motion to impound portions of it made by the defense, and they gave the court a redacted copy. And we're waiting. Still waiting. Let me see what Olivia has to say. Yeah, they're jealous. Crafty Chris says they're jealous that Nan isn't donating an hour's pay to them. That's right. She's been very generous to not only the Karen Read Defense Fund and also the creators that are covering Karen Read's case, because she also wants the word out. Yes, awesome. So 518 has not been scanned yet. We're just waiting to see if it pops up. If it doesn't, we're going to come back anyway, because if we get a copy of the motion to dismiss, we're going to come right back and talk about it. So maybe we will end here and then we will come back. Just make sure you have your notifications set because, you don't want to miss it. Lisa Marie, I think we addressed this. Thank you so very much for that. Going to give it another minute. Talk amongst yourselves if you have any thoughts, questions, comments, concerns before we wrap this stream. And we may go right into another one, depending on when, if and when, the motion to dismiss is docketed and scanned, and or the rulings from last week's hearing. Yeah, I don't want to tell you about Paul's wife because that's not my place to do that. If you want to find out about it, you can go to Turtle Boy's website, turtleboynews.com maybe. He published a whole story on it the other day. Some text messages surfaced allegedly between Paul O'Keefe and a woman who he was speaking to on some kind of social media. He professed his love for her, et cetera, et cetera. It's you'll never unsee it. So I don't know. Somebody said I had to unsubscribe and resubscribe. I can't chat. People are sending me all kinds of emails. Like I can't. This stream today is set on a 2-day subscriber level. So unless you've been a subscriber for 2 days or more, you will not be able to chat. It's just the way it has to be because the trolls have to be. They find their way in anyway, but that's just the way it has to be. So the inundation of emails that I get, check me, check this, check that. I have mods that man the email and respond to the emails and do the research on that. So there's no way for me to stop my stream, find out if you're blocked, unblock you. I just can't do it. I'm sorry. YouTube is being wild. They're being wild. But that's all there is. Okay. So if you have sent me an email such as like that, I'll take it under advisement. I have turned over a lot less. We were duped. Says, just a thought. I believe John knew something about Sandra Birchmore's case, and that's why I believe he was killed in the house. You're not alone. A lot of people feel that way. A lot of people think that. A lot of people think that. Well, okay. So Cindy, I'm sorry, Cindy. I can't. There's nothing that I can do to change the settings right now in the middle of a stream so that you can chat. You had to unsubscribe and then resubscribe. I'm sorry. Please accept my deepest apologies. I'm so sorry. That is the way the stream is set for a reason. And if I made exceptions for everyone, I feel like why am I even addressing that? I don't even know. Okay. Yes, trolls means that you're preaching the truth. I know. Oh, John Lawler, did he just die today? Suze? Iceman says, I love the setting like that. And so sorry. Yeah. I mean, if you come in here, and I'm not saying Cindy, that has nothing to do with you. But anybody who comes in here and bashes my mods or blocks my mods is getting blocked. It's like a no tolerance policy. Like, no, you can't do that. I'm not getting AI bots. Thank you, Lindsay. No, I'm not. I have moderators who do the real job of real people in real time. And I trust their judgment 100%. Not even going to get into it anymore. But anyway, Monique, thank you for the 10, Coach Mo. Can't thank you enough for your excellent, fantastic coverage and your sense of humor while you're at it. Who needs mainstream media? And we have you. Big hugs and love to you. Coach Mo, thank you for the love. I love you too. I love you too with all of my heart. If I don't see you soon, I'm going to die. Yeah, and I don't know who this is either. In Lamone Pickets. Says you're blocked. I don't know. I don't know if you haven't been in the thing. I don't know. It's not set to members. I don't know. I don't know what the reasons are. I don't know if if the mods have warned you several times about things you're putting in chat, like spreading misinformation or you bashing other creators or bashing people or defaming people. It gets deleted. I'm sorry. I'm just not going to tolerate it. There's other places that you can do that and that's tolerated. And I'm not sorry about it. I'm not sorry about it. I'm just not. So, all right, we're going to wrap this for now because of, all the distractions and things and stuff like that. And we are going to come back as soon as we can get a hold of that docket number 518. And also, hopefully the motion to dismiss will be docketed and we'll be able to look at it, even if it's heavily redacted. Hopefully they're not going to block the whole entire thing and block us from seeing the whole entire thing. And if they do, you can bet your ass it's because they don't want the world to know the truth. They don't want to know all the reasons that the defense is moving to dismiss the case based on egregious governmental misconduct, because they don't want you to know all of the things that have been hidden and shuffled and that have all of the things that have been disappeared in this case and proctored and doctored and hidden and all of the nefarious, as Brennan would say, activities that have gone on behind the scenes. They don't want you to see it. Did I see the oral arguments, Matthias and the mic? No, honey, I just haven't. There's only so many hours in a day, babe. I don't know how long they were, but I have not had an opportunity to watch them. But thank you, Mathis. I know you've asked me to cover that a couple of times, but I just can't. I'm kind of single thread here right now. We're coming up on this second re-persecution, and this is, it's hard for me to. I don't like to do it half-assed, so I'm not gonna not do the research, not look at the papers, not find the documents. I'm not gonna, so I although I wish I had time for everything, I'm sorry, sweetie, but I just can't. All right, make sure you have all notifications set, and make sure that you hit the subscribe button because it's free, and make sure that you make your plans to be able to come back here as soon as these documents drop, because we're coming back and we're going to be here to cover it as soon as it does. Thank you to the moderators for keeping the chat classy today. I know it's not always easy when we talk about the Karen Reed case, and you guys are amazing, and you work overtime and double time and triple time, and I love you with all of my heart. Replay viewers, smash the like, do all the things, YouTube likes, hit the like button, comment respectfully, and as I always say, to end every stream, stay cool, stay kind, stay classy. I know you can do it. I know you can do it. I know you can. Rise above. Your life is going to be so much better for it. See you real soon. Peace, my friends. Peace.